certified.
Yesterday, I have challenged order, I have challenged a review order, yesterday, your lordship rejected that order, rejected that appeal, and direct us to give a liberty to file an appeal challenging the parent order,
Oh.
Now, yesterday, itself, I have applied for certified copy. I could not get it, My urgency is this, Tomorrow, the date is fixed for contempt, I am apprehending that if I could not file this appeal, rule will
File it with an undertaking today. You file it.
My lord, may I be permitted to mention one item, my lord? This is for inclusion in the list, my lord.
Give the inclusion slips.
Same player, my lord, inclusion in the list, determination.
Please give.
My senior friend has just mentioned this matter. It is only one prayer, lordship. This matter, lordship, that it comes in from outside itself. It's lordship,
Let it come in the list.
Just one thing, sir. Humbly praying to the lordship, if subject to lordship approval. So 4 days, lordship, if can be avoided. Lordship, because the learning thing here, it will come from outside.
Sir, let it come on the list. You want an adjournment already. When it comes, then you make that prayer.
4 days, lordship, 17, 19, 20, and 24.
So we should pass an order that not list on these 4 dates. What do you want, sir? Let it come on the list. Unnecessarily, you are wasting time in the morning. Yes. Unusual. Yes. To be mentioned tomorrow morning. You please inform the other side. Yes. Tomorrow we are having that list. Yes, include it in tomorrow's list. We are not having much time tomorrow, but anyway, let us. Yes.
Item number 1.
One, may I please, the lordship, I am for the petition.
My lord, I want to submit my reports.
What is that?
Reports, my lord.
Yes, what is your report?
My lord, kindly come to annexure 8, my lord. I folded that annexure.
Go to this.
Annexure 8 of my report, my lord. Last.
Give me the report.
Just before annexure R9.
Where is the report? Where is the report? It's already filed. She is filing it right now. Report.
Yes, yes. I didn't I-
There is no paging.
Resignations. My lord.
Why, madam?
My lord, then kindly I can
Basic, you know, please be kind to us. Please be kind to us. Paginate.
My lord, I can only take the pleading.
Just tell us what is your stand.
My stand
You
like,
are let them
at
paginate
the time of editing, the date of editing.
at the time of
editing the category.
that window which was allowed.
Yes, that what he has done, the petitioner done that under reserved. So petitioner has treated under reserved.
Oh, at the time the window was open for any corrections, he has
Corrections,
made
that time he corrected under reserved.
Okay.
And the petitioner
My lord,
treated as
my specific case is that I have.
You want to file a
But
exception?
I am not.
You want to file an exception?
Yes, of course,
All
my
right.
lord, because of
Let
the
the
reason I
report
have
be taken
never
on
used the,
record.
correction
Exception to
so,
be filed
how could it be?
within a week. Let him have his opportunity. List after 1 week.
I have served.
Designation.
I have.
Designation code. This is not right. Your lordship say fix the matter on
9th.
as top because
No more top.
Today itself the interview is going on.
What can be done?
My lord,
You have changed your category. We'll see.
I have not changed, my lord. This is my specific case.
It's showing.
I have
that
never
it's
changed.
showing.
How do you know?
Screen-
Today, how do you know?
Well, my client is saying
Your
so.
client instructed you to make certain assertions which he made in the application or
Application,
petition.
yes.
Now they have come out with something new. How do you know that that is false?
My lord,
That's why we are asking
my
you.
lord, they can
Today you can't
manipulate it.
deny
They
it.
can manipulate it.
You cannot deny it today.
My lord, yes, that's
Yes.
that's why I am
Nine.
not-
Nine.
Item number 2.
That is where Malam superannuated employee has been directed to reinstate in the service and ballot and asked for de novo inquiry. That was not possible, ballot on the last occasion I submitted, and your lordship called for ballot instruction with the inquiry report has been served upon the petitioner respondent or not. Ballot so far my instruction from the ballot general manager of particular area that records are not available, my lord, and because the mines has closed down, my lord, June 2014, my lord. Shakib.
But that was not served. They have admitted that in their opposition.
Hmm. Where is the Leonard single judge order? That's
So that's all that page 68. No, that's on page 68.
and you filed an opposition before the honorable single judge.
Yes.
Can we see your opposition? Where is that?
Kindly come to page
Page
50.
50.
Please. Without hearing you, will not pass an order. Please have patience. Yes.
Page 50. No,
Page.
Page 50 starts from page 50.
You have not enclosed the annexures.
My lord, change brief, my lord, that's a very difficult.
You have annexure R by 4 of your opposition in your file somewhere.
The report ফেরত দিয়ে দিয়েছে। হ্যাঁ, ওটা পেটিং এ
My lord, supply করতে পারবে? Difficult, my lord. Erstwhile advocate on record expired, my lord. Thereafter it is change brief and it has come to my advocate on record. If my learned friend all along appearing on behalf of the, my lord, on behalf of the petitioner, if he can.
copy of writ petition on.
Change brief of Archie. Hold on. Okay, that is- Office power, it is coming.
And at which page is the order passed in 880 of 2002?
Justice Ben Fish.
Yes, please.
Last time. My lord, page 79. Justice বিশ্বাস, as the lordship then was asked to follow the.
Please let us read. Please let us read.
Lordship-
And this P6, is P6 anywhere on record or that is also not?
P6. And my lord, on the basis of Justice Bishop's order, very next page, my lord, the authority has passed the order, my lord, page 82.
So P4, P6, both are not there. You have it,
I have the copy of the writ petition.
both documents.
Okay. With the new product. অনেক কথা। তো আগে তারপর থেকে নেই।
And P4 of the opposition?
If opposition's copy, I just
You don't have the writ records.
Your lordship may call for records, otherwise, my lord, because
No, but there is nothing in your opposition to suggest that it was ever served on them.
yes, that's true, my lord.
In fact, you have struck off
Yes, that's
the
true, my
line
lord.
where you say that it was
Even if in the present today's report, it also indicated that whether it has served or not, my lord, then adverse presumption may be taken up that it was not served.
no, that is, we are talking of something on a higher pedestal than presumption. You had the opportunity in the opposition, but you did not say that it was served.
they have said. Kindly come to page 57. They have admitted that that was not served. In the writ petition paragraph 25, I have taken a specific point that the opposition.
Page 57, where is the admission?
Page 57,
Huh.
paragraph 25. 57. Paragraph 17, madam, sir. I say that the order of dismissal was issued on 18 February 1993 and as such he is not entitled to any report of the inquiry officer, nor he can claim for setting aside the order of dismissal on the ground that non-service of the inquiry reports.
What remains?
Second so-cause notice was never served upon us. And without serving the second so-cause notice, they have issued the order of termination. Okay.
You also did not participate. You asked them to stay the proceedings.
Participated. I have participated. Kindly take some my writ petition.
Yes, made the representation, my lord, Annex P7.
Where is the
Page 35. I have taken a specific point that I was not allowed to cross-examine my witnesses.
page 35?
Page 35. The charge was that I have assaulted some officer.
Yes, you have used abusive language and you have assaulted.
On the same issue, a criminal case was also where I have been declared honorable acquittal.
Where have you said that you are not allowed to?
Well, kindly come to page 30. In reference to the above mentioned charge sheet and inquiry against me, I beg to record my strong protest against the total proceeding of the so-called inquiry. The total inquiry was conducted on one side and
You are
without
reading from
allowing
which page, sir?
cross-examine the
Which page?
page 35 of the writ petition. I have handed over.
Paragraph?
Paragraph page 35 is the letter and it's a P3. A copy of the writ petition. Right? Takes up the copy of the writ petition. This copy of the
Oh, you have given us.
lordship. Because this standard annexure has not been appended with this copy of the stay application. But without giving me the proper opportunity of my cross-examining the witnesses, they have proceeded. They have passed the final order without my supplying me the copy of the my lord inquiry.
Where's,
officer report.
where's the inquiry report?
But the inquiry report I have not annexed because I was not served.
Have you annexed anywhere? You have also not annexed. The disciplinary authorities order,
Disciplinary authorities order is at Malod, page 55,
52.
55 of the disciplinary. Got it. The order dated 11th May 2004, passed by the Honorable Justice Jayanta Kumar Vishwas in the matter of WP number such and such, the Sri Orchid Ram Kahar versus UCL and others, hearing was held by the judge,
Hmm.
Ajuria area in his chamber with the opportunity given to the Orchid Ram Kahar and in compliance of the above mentioned order dated 11th May 2004 of the Honorable High Court, Calcutta, date of hearing was fixed on 17th July 2004.
That is not the inquiry report.
Not inquiry report, my lord.
That's not the disciplinary authorities order also.
Yes. In compliance with order, my lord, Justice Vishwas was remand back the matter before the authority following the my lord, Paul Anthony's.
See, after the inquiry was concluded, disciplinary authority recorded an order of punishment. Then the criminal proceeding was taken to its conclusion. In appeal, he was acquitted. Then he filed a representation saying that in view of my acquittal, the matter should be relooked. The matter was remanded by this court because they refused to relook to it. This is an order passed thereafter.
Yes.
Where is the neither inquiry report nor disciplinary authorities order? Nothing is there. So what is there?
Yes, my lord, I'm saying nothing is there.
Impossible.
Your lordship may call for inter.
Why? Why? For your lapse. Why should we go undertake such an exercise? You are not interested in relying on things, then you have not placed it on record. If you were interested, you would have placed it. Then what have you challenged?
Well, I challenge because the order passed by the learned single judge, it is very impossible, supervening impossibility to implement the order because petitioner reached at the age of superannuation in the June 2014, whereas the order passed in the December 2014.
Where is that order?
Well, page 68 of the application. We'll kindly see first the date of the order, 24 December 2014.
24/12.
2014. And follow the findings of the court, kindly see page 72 onwards. In case it is found that the petitioner had not been dismissed after complying with the procedural requirements, the respondent number 3 shall take a fresh decision in accordance with law laid down by the Supreme Court in the case referred to above within 8 weeks from the date of communication of the order after giving opportunity of hearing and shall dispose of the representation made by the petitioner which was directed to be disposed of by this court in the earlier petition. Since the respondent number 3 had observed this court on an earlier occasion did not direct the appropriate authority to set aside the order of dismissal by way of abundant precaution, I make it clear that if respondents hold that in the light of the judgments referred to above, the dismissal is not a sustainable one or a lesser punishment might be considered, the same can be passed by them substituting the earlier order of dismissal. In the case it is found that no copy of the inquiry report was served upon the petitioner, the order of the dismissal shall not only be revoked, the respondent authority shall start paying the current salary to the petitioner, which he would have been entitled to have had he been in service. The payment of area salary shall we defer till the conclusion of the fresh round of disciplinary proceeding. The writ petition is disposed of with direction. Since the petitioner is out of employment more than 2 decades, I direct the time frame fixed by me, this order to be treated as mandatory. I make it clear that while passing the order, I have not gone into the merits of the respective case. This order is not interpreted as an expression of the court in the matter of in favor of the rights of any parties, which shall be decided by the appropriate authority in accordance with law. As we reached the age of superannuation, it is supervening impossibility on the part of us to reinstate him in the service. Then on the last occasion, what is fallen from your lordship, why you have not had you not continued the disciplinary proceeding, second part of the order. So for the my lord, our standing order does not permit to after superannuation to continue the disciplinary proceeding. If it is official category, my lord, then my lord, as per the Colonial rules, my lord, after retirement, it should be treated as a deemed service and continue the disciplinary proceeding. So for the my lord, workman consent is concerned, my lord. So there is no rules of there is no standing orders, my lord. After superannuation, disciplinary proceeding would be continued.
What is the date of the charge memo? Can you give us some dates?
Well, the charge memo is at page 34 of my writ petition.
Yes.
The date is 20th November 1991.
20,
1991.
20,
91 and
20.
20,
20 days.
November 1991. And the final order of the disciplinary authority is at page 36 of my writ petition.
Yes. That is of which date?
That is, my lord, 18 February 1993.
And the FIR is of which date? Perhaps it is after the finding of the inquiry, the disciplinary authority, or is it prior to that?
The FIR was, my lord, issued in the year 1991
FIR instituted in 91 itself.
itself. Your lordship, kindly come to page 37 of my writ petition. The criminal case was registered in connection with GR case number 1231 of 1991. 1213 of 1991.
And the date of conviction was
But FIR date is not reflected.
30th July 99.
July 1999.
99.
Yes.
And then the appellate authority's order has come. Twelve 4/2001.
2000. April 2001.
12th April 2001.
Yes. Judgment passed by the
The appellate authority's judgment.
appellate authority.
12th April 2001.
High Court order. 42.
Writ petition.
And yeah, 12th April.
Two 2002 writ petition. What was the number of the 2002 writ petition?
Petition number is letter.
880 WP 880 W 2002.
880
W of 2000.
2002. And that order is
That order date is 11 May 2004.
that is on record.
That is I have annexed it to the writ petition. That is at page 47 of the writ petition. They did not even touch the murder emperor until his case in their recent order.
Criminal, what a criminal case.
And then the order at page 55 was passed.
Yes, that's
What is the date of that order?
Order date is my lord 11th. পরে রাইট কপিটা না আমাদের এটা
The date is not legible.
Must be by a covering, must have a covering letter or something. Must have said in the prayer, the communication which you have challenged must have been mentioned in the prayer, in your writ petition.
September 2004.
Then only they observe that no direction of honorable court was found anywhere to set aside the dismissal order number such and such dated 18 February 1993 issued by the general manager Kajoria area to Harkit Ram Kahar, ex vehicle
And
driver.
the order dated 27th.
No, prayer B. Look at prayer B. In your writ petition, copy of which you have given us.
27 September 2000. It's 28.
Page 28, yes. (27/9, 2004). And that was put to challenge in the present proceeding.
Yes. 2006, he has challenged the same.
The entire disciplinary proceedings was under challenge because I have taken a specific point that no second so cause notice was served upon this. That is at page 20, paragraph 25 of my.
We have just seen prayer 1. You have challenged the dismissal order also, 18 to 1993. And then the impugned order was passed in the present proceeding. So your submission is that by the time the order was passed, he was already.
Super annuity.
Superannuated.
Neither while the petitioner has pointed out the same, it is also it is a contributory negligence of the both sides, my lord. This is true. Therefore, it is a supervening impossibility to reinstate him because our rule does not permit, well, the certified standing order does not.
So has he ever been substituted? When you have taken that ground in your appeal, did you substitute him? You are pursuing appeal against a dead person.
Not retired person, not dead person.
Oh, he has retired. Okay.
Retired. Not dead person. There is no question of because our certified standing order does not permit. And well, so far the date of retirement has been declared on the basis of the B form registered, my lord. I have already produced the same. It is so far the Mining Act is concerned, my lord, it is a statutory document.
What is his date of retirement?
June 30th June 2014.
14.
14. Order passed, my lord, on December 24th December 2014.
So what is the effect? Let us presume that on the day the writ court passed the order, he had already retired. And there was a finding that there is no inquiry report. Then what is to be done? If you have allowed him to retire and there is a finding that there is a violation of the procedure of fairness, how does that change anything?
That is, Malad, the court has directed to start de novo inquiry. That's
Not directed, that's more liberty given to you.
liberty.
So
given.
that liberty, therefore, we are saying, if it was informed to the court that he is no longer in service, then at best the liberty would not be given. How does that change the situation? The
Right.
fact remains that report was never served on him. Now, when there is a finding and that is not in dispute, then a mere fact of his retirement will hardly make any difference. You have not been able to show us that it was served. Is there any averment in the appeal that it was served?
No.
There is no averment in the counter or opposition also. So therefore, that situation is an admitted position arising from the records. Disciplinary authority's order further fortifies this view that we are taking. You see the order of the disciplinary authority, page 36. There is no scope for any conclusion otherwise. So only possible conclusion from based on the documents that we are reading.
That proceedings will go. I'm relying upon the judgment of 1991. Volume 1, page 5.
Page 36 of the writ petition, you see.
My landlord has supplied this.
No, where is the disciplinary authority's order? Not 36.
But
Is it?
this is not annexed with the stay application. This is annexed with the writ petition. my lord.
No, you have annexed it.
I have served a copy of the writ petition. It is annexed with the writ petition.
Exactly. Charge sheet number such and such was served upon you for mm,
You see the fourth paragraph, third and fourth. According to the report of the inquiry officer, you have been
you
guilty of.
guilty of charges for assault, indecent behavior and abusing under rule
So
7.
and so of the standing order. Now next paragraph.
I have carefully considered the report of the inquiry officer and said record of the case. I have further considered your past records, character and conduct as well as the circumstances of the case under
He
which
neither says that the report was served, you have not replied, nor he says that the report was served, we have considered your reply. There's nothing. So how long did he have after the punishment order? From 93 till 2014. So he had 11 years more service. And why you did not assail the finding of the disciplinary authority till the conclusion of the criminal proceeding?
But initially, that was writ petition was moved where the authority was directed to consider the final order as per the judgment of imperial authority.
So therefore, there was an opportunity to you to raise the issue regarding a procedural violation from submission of from the date of the punishment order 93 till the conviction was set aside.
even is
In 2001,
The driver, he was out of service.
94, 95, 96, 97, 98, 99, 2000, 2001. So 8 years, you did not challenge it.
and from his representation it is not also reflected. Last representation 17th July 2004 at page 51 of the writ petition. Nothing has been reflected how he has been prejudiced for non-supplying of the inquiry report. Nothing has been spelled out.
But that is not required. It is well settled proposition.
Yes,
that non-supply of second
Ranjan
report is a violation
case
of the
and
principle of
after
matter of justice.
ECL Karunakar
ECIL versus Karunakar judgment, now the law is settled, there is nothing. Does not hinge on what is it from 93. He filed the writ petition. The second writ petition was filed. Can you give us the date?
2006,
Sorry, the representation date after the appellate order, after the order of the appellate court. Date of representation.
last representation is, my lord,
Date of representation prior to the earlier writ petition, which he says was not being considered.
demanded
December 10, 2001.
December 10, 2001.
December
10, 2001.
2001.
2001.
And where is that in your writ petition? At which page?
No, that is not annexed with the writ petition, but that is reflected from the order passed in the earlier writ petition. That is at page 47 of the writ.
Page 48, my lord, the disciplinary authority is hereby directed to consider the petitioner's representation dated December 10, 2001 in the light of the above mentioned Supreme Court decision.
Punishment.
Six is a part of it. So it's important. Not got a blue card. Would there be secular activity would not be high? 6 another key. 6 clear. Move to another key. What's your amount of service?
21. So you are out of service for 21 years.
From 1993 to 2004.
ইন্টারকোড আলাদা করা হলো যেগুলো মিসলিনিয়াস গুলো একবার হয়ে যাচ্ছে ইন্টারকোড আলাদা না না করে দিলে সবগুলো দেখতে কিছু অ্যাপিলটা
You will not get any benefit.
সার্ভিস এখানে আছে সার্ভিস
State.
এখানে আছে
এখানে ওইটা আলাদা।
That's all. You want to, anything else you want to submit? Your main submission is that it is impossible to carry out. You have heard the learned advocate representing the parties. Considered the record.
Item number 3.
Yes, we'll pass the order. We have recorded.
Yes. Malad, he has never raised the point, Malad, after 8 years, Malad, he cannot.
You didn't argue that, sir. We have raised that issue. Don't worry. When we have seen something, we will deal with it. Yes. Hmm. Biraj.
Yes. Appears on behalf of the appellant.
দিও না ভোগ তারপর তার মানে নষ্ট হবে
Give the brief of 1549. 1549. 1549. This is the. This is the. Some of the.
Yes. Yes. Lord, the petitioner before Lord Sigmund was initially appointed in the University of Kolani as an assistant engineer, electrical. Lord, on 11th December 1972. 11th December 1972, he was appointed as an electrical engineer, assistant engineer electrical in Kolani University. Lord, subsequently, the Bidhan Chandra Krishi Vishwavidyalaya was set up, and he was transferred from Kolani University to Bidhan Chandra Vishwavidyalaya. Lord, in 1974, by the government of West Bengal, he was transferred in the year 1974. But thereafter, what happened? But he had been continuing in service with full satisfaction of the authorities and took charge of setting up the university, formation of the university at the very initial stage. But thereafter, what happened? During his service, what happened? The Bidhan Chandra Krishi Vishwavidyalaya made an advertisement for appointment of electrical engineer in the said university, and the petitioner was the only electrical engineer. He challenged that order. That advertisement was challenged, and by filing a writ petition before this honorable court, and this honorable court was pleased to stay. And accordingly, that during pendency of this, the writ petition was pending, and it was not disposed of. Ultimately, they didn't proceed with this advertisement, and the petitioner was only electrical engineer in the Bidhan Chandra Krishi Vishwavidyalaya. But thereafter, what happened? Without assigning any reason, petitioner was suspended in the year 1943. The petitioner again challenged that order, and the suspension order was stayed. No disciplinary proceeding was initiated. Thereafter, my lord, during pendency of the writ petition, petitioner was allowed to join the service and he was directed to pay full salary. So this was continuing. Thereafter, Lord, by notification, the Lord, dated 3rd March 2002, the career advancement scheme was introduced by the government of West Bengal and it was communicated to the Bidhan Chandra Krishi Vishwavidyalaya. Your Lordship will get at page 34 of the paper book that notification. And Lord, accordingly, that is the self-appraisal scheme.
When did you file the paper book?
Paper book has been filed. In the department, it was filed last occasion.
When did you file it? That's why we are asking.
Lord, in terms of direction passed by the Honorable Justice Mantha, paper book was filed as well as Lord, it was served upon the respondent authorities.
That is the report, sir. That page that you have flipped, that is the report.
Yes.
Who is for the respondent? You are appearing.
Nobody, neither state nor the university authority.
Who is appearing for the respondent?
No, nobody. Nobody is appearing, Lord. Your Lordship kindly see.
So you will represent. Universities don't have their own panel. They're represented by. No, government will be a party that is there, but the university has its own panel. Obviously, yes. That much is, it is obvious. Yes, yes.
Whether the paper books have been filed, Lord, by the affidavit of service. We have served the paper book upon the.
No, service does not mean filing.
No, Lord, that end.
Nobody is saying that you have not served. You will have to give us. The office has reported that is not filed. Therefore, we asked you, is there any date, detail?
It appears, Lord, that.
If there is no date or detail, then we'll have to accept the report.
Lord, let me check, Lord, it has been filed and it was sent. Lord, let me take instruction.
File a fresh file. Give us the copies.
My lord.
You have since you. Who have you?
Council direct to the university as none appeared.
Till now, none has appeared.
No.
On any date.
After question also, Lord, this is Justice Mantha's division bench. They didn't appear. So I said, check, Lord, because Mr. Pradhananda Ganguly was
No,
represented.
there was a direction for notice in July 25.
Yes, Lord. Immediately thereafter, it was.
You have filed affidavit of service.
Yes, in record. Lord, it was filed in court before their lordship.
Yes, it is there. Just let us see.
Respondents have received. তো file করতে কিছু লেখা আছে?
When can you file the paper book?
Not, by next week, you know.
As per the office report, the paper book has not been filed pursuant to the earlier orders passed in the present proceedings. Direction for filing paper. Direction. That's right there. Yeah. This thing is in it. Yeah, what did we say? Not been filed, full stop, the learned advocate representing the appellant submits that he would file the paper book, comma, copy of which has been served on the respondents within a week, full stop. We find that despite notice having served on the respondents earlier, there is none to represent the respondents, full stop. We therefore consider it appropriate that notice be sent afresh regarding listing of this matter, giving another opportunity to the respondents to be represented when the matter is taken up on 12th of February. On that day, affidavit of service be filed. Yes.
No, a requisition may be sent to code number 13. Papers are there. It was handed over to the honorable judges. Court. That particular department has noted that. Requisition will be sent to the court. Otherwise, it will not.
The previous court. So it remains in the court unless the next court. If they don't send it to the department.
The same, the department might have responded with that. Yeah.
So for these things, the court has to pass a direction. They don't do it on their.
Then what we have to approach the code number 13 officer and.
No, sir, I am trying to ascertain the procedure. The office is not supposed to do it on its own, or for that everything the.
Because the code officer should have sent the entire record with the paper book. It is not true. In view of the.
You people insist on filing in court. That's why we are asking you. We would rather you file it in the department, but you always say that we want to file it in court. Then this will happen. You should file it in the department.
Then we have to take.
Unnecessary delay, two adjournments for no purpose. Strike off the order. We are informed by the learned advocate for the appellant that paper book was filed in court when the matter
But today I'm praying your lordship to file supplementary affidavit, annexing the order, my lord, passed by the authority, my lord.
What order?
Order, my lord, what has happened, my lord, they published a notification. The issue is, my lord, in the writ petition is that, my lord, we are the LD of secretariat. We have better responsibility than the LDC of the directorate. This is the issue. Now, during the pendency of the WPST before this honorable court, one notification was issued by the authority saying that they will consider certain things. In the paragraph number 7 of this notification, my lord, regarding pay of the secretariat and LDA, my lord, has to be considered. Now, my lord, we filed.
This, in such sense, you are seeking enhancement.
No, the court has directed the
Review and recommendation in respect of our pay scale. Now, my lord, what has happened, my lord, after notification of 2015, we filed an application, CAN application, connection with the writ petition. In the CAN application, the order was passed by the Honorable Justice Devanshu Basas, that immediately constitute a committee. Chief Secretary directed, my lord, to consider our case. Now, my lord, 29 December 2025, my lord,
Has finally been considered.
Nothing has been done.
So now
Now,
you have to challenge that order.
well, we are challenging also, my lord, the grievances, main grievances, where the notification has been issued, that has not been considered by the authority as yet. Kindly see the page 28. Sorry.
Order of His Lordship Justice Basar, Division Bench.
Yes. Kindly see the order. Page 13.
Order is of which date?
16 June 2023.
এগুলো থাকুক এইটা দাও কি খেটেছে এখানে এটা কি হয়েছে
Now, our claim in terms of the notification dated 10th September 2020, 2015, that has never been considered.
Therefore, the order of the earlier order of the bench
Yes.
has been complied, but you have not got any benefit of the compliance. Therefore, we asked you, whatever they have considered, it may be right, it may be wrong, we don't know, we have not seen it yet. But that is required to be challenged. Unless it is challenged, how can we look into it?
But
This is not a contempt proceedings.
yes.
There is a claim you have come forward with. The erstwhile bench thought it proper that let it be considered in terms of some notification of 15th November. Now their consideration is not to your liking. Then what is to be done?
My lord, in this matter, my lord, I appear virtually for the added respondents. The thing is this, my lord, we also took part in the proceedings, my lord, undertaken by the
We
Chief
are just now
Secretary.
trying to interact with the appellant, Mr. Rai. Please wait.
Yes, my lord.
With the writ petitioner, yes.
Pending writ petition, they pass the order, my lord.
So therefore we are asking you,
By filing a CAN application, we can challenge.
no
whatever,
Yes.
whatever,
pursuant to the direction of this
whether you will be able to make out all the grounds, whether it will lead to more confusion or whether it is in your interest to go for filing afresh, that is for you to decide. But there has to be a challenge to the order.
Yes.
Unless there is a challenge and they are given an opportunity, we cannot proceed.
I am filing the supplementary, just putting the
So therefore, the order of 16/6/23 is complied,
Yeah.
but not to your liking.
the reason
You
order
will say it has not been considered in light of that notification.
reason order passed by the chief
10/9 to 10/9/15 notification, you have annexed it in this.
in the MI CAN application, CAN number 11368 of 2016. Old CAN, 2016 CAN.
Therefore, it will become virtually impossible to go through the brief like this.
Well, kindly.
Sorry. That is the 10/9/15. You should have annexed it to this supplementary for our convenience. You could have annexed it.
There is a direction upon the government to constitute a committee and to submit a report before the court. We have constituted a committee and no decision has been published in the official gazette.
So this is nothing. This is only a decision.
Paragraph 8.
Huh?
Next page. The subject. Scale, pay scale.
To review and recommend.
Recommend.
So they have recommended.
There's nothing, but what has happened, my lord? The order passed by the chief secretary in my supplementary affidavit. Kindly see the page.
All right, we'll just look into it. Give us 5 minutes.
Yes, yes, give us 5. Yes. And the reasoned order passed by the Chief Secretary of State of West Bengal also consider, kindly see paragraph number 5, supplementary affidavit, page 19. Supplementary, page 19. The order, reasoned order passed by the Chief Secretary, Government of West Bengal. It starts from page 17. Relevant is page 19, paragraph 5. Page 19, order starts from page 17. Relevant is page 19, paragraph 5, where the with regard to the pay scale of head assistants and section officer SO of the secretariat, let it be mentioned here that separate pay structure for the above two posts exist even in ROPAS 2019. However, it appears that the value of such higher structure existed in ROPA 1981 has not been maintained subsequently in ROPA rules. And in the final notification, that has never been considered. And we have submitted our written notes to that effect also at the time of hearing. Admittedly, new cause of action.
We thought so, therefore we said.
Yes.
Now they have, the entire prospectus is changed. They say not only you are required to be seen, but they have to see the field officers clerks also. They say we are performing more onerous work.
And kindly consider once, well,
Therefore, that
29 December 2025 never said regarding the pay scale.
that is because during the course of hearing it has emerged. We don't know the correctness of such things, but they have come forward. Perhaps Mr. Rai's clients.
But in this matter, Lord, I have some submissions. Lord, I appear for the added respondents who are regional employees, not secretarial. Now,
In the
thing
field
is,
offices.
yes, regional employees. Now, Lord, we were also invited in the proceedings undertaken by the Chief Secretary. Lord, we also submitted written statements. Our grievances will remain unaddressed.
So
Our
now they have
grievances,
said they will consider both.
but my instruction is that our grievances, that the reasoned order does not address our issues.
It does not address their issue also. It says we will consider both.
Therefore, things
What
remain.
is the final decision on their claim?
Well, kindly, I attached page 28 once. The notification, 29 December 2025. See the observations, decisions.
According to my presumption, the place cover.
Huh?
The face
Fresh cause of action. We are fighting since 2009.
and according to the court directed to consult the committee, matter placed before the cabinet approved it, then we publish the gazette. If you agree, anybody agree by this?
Let us see the order, page 28. This is a notification, gazette notification.
Gazette notification.
They have made some restructuring. They have changed the name also.
But my lord, we have submitted our written notes to that effect. Kindly come to page 22, detailed written notes. Nothing has been considered. Now, my lord, their action, my lord, already frustrated the notification of 2015 itself. If there is a notification issued for giving some benefit to the employees, that should be considered first. And the Honorable High Court Division Bench of this Honorable Court to that effect disposed of our CAN application, directing the Chief Secretary to decide the issue.
See the point 8 in the notification. Anyway, we should not make many comments. If you want, you can
Yes, kindly adjourn the matter for a week.
file a fresh writ petition. It will be pointless to just increase the volume of this writ petition now.
Page 53 of the writ petition become manufacturers.
He wants to file fresh writ petition, Mr. Mukherjee. You don't want him to file a writ.
We cannot.
You
stop.
don't want him to file a fresh writ petition.
That is the.
The learned advocate appearing for
But
the.
Only one submission, Lord.
Yes, you don't want him to file a fresh writ petition.
No, Lord. Thing is, this, Lord, the parties have to approach the tribunal. Not in
Whatever.
No, we can file it.
Whatever. The learned advocate for the writ petitioner submits that a notification dated 29/12/25 does not address the issues raised by them and lacks consideration of their claim, which they propose to assail in appropriate proceedings in accordance with law. Stop. With such liberty, the present writ proceedings are disposed of.
I'm grateful to my Lord.
May I take back the copy of the CAN application?
Yes, you may. There is a CAN or supplementary?
Supplementary.
No, CAN application.
CAN for?
CAN for compliance of the notification.
You want to take it back?
2016, the CAN filing given here 2016.
Yes.
On the basis of that CAN division bench passed the order.
So why do you want to take it back?
Xerox copy, but I have the one copy. My copy.
CAN number code.
CAN number
11368.
How he
No,
can take
it's
it?
a quoted copy. It is a quoted copy.
একটা copy.
Oh, there is an extra copy.
Yes, my copy.
Oh. If there is an extra copy, then for that order is not required. Let me see. Let us see. No, this is not Xerox. If there is a Xerox, you get it. Why not? Just that order is not pending applications, if any, stand disposed of.
But I got it. This is the copy. Obliged. Get it.
Item number 5.
Lordship, I am for the appellant. Lordship, I am led by Mr. Supriya Chattopadhyay and praying for 2 weeks time, Lordship. His mother is not well for medical purpose. He is quite busy. He is not available right now.
We are informed by MS so that Mr. Bhattacharya is to be. Mr. Bhattacharya, who was in the case, he is leading the arguments.
That is Mr. Chattopadhyay.
Huh?
Supriya Chattopadhyay. This Chattopadhyay.
Supriya
That is Chattopadhyay.
Is aiming to his, is attending to his ailing father.
No, his mother is not well.
Attending to his ailing mother. Of where he made for the foundation of matter stand as well. This one.
না না বিরাজ নিয়েছে আইটেম নাম্বার 6
Madam, I am for the state, my lord. Pursuant to earlier order, I intimated the learned advocate for the petitioner. I intimated, but today they are not here. I was told by the learned advocate for the petitioner that the petitioner has died long back, and they have not contacted with the advocate for the petitioner for a long time. Petitioner died long back.
We don't know. He is not here.
None appears on behalf of the petitioner.
Earlier also.
It appears that on earlier occasion, the petitioner was found absent. That on the occasion, nobody was present to represent the petitioner in this case.
Okay, my lord,
It appears that
আইটেম নাম্বার 7
The petitioner, my lord. Petitioner hearing is a petitioner hearing is a contingent manual working from 2004 and was demobilized by order dated 2016, my lord.
Can you please resubmit what you are saying?
I'm saying that, my lord, the petitioner is a contingent manual. He
Is a
contingent manual.
contingent menial.
He was working in the office of Superintendent of Police Barashat from 2004, my lord. Continuously worked without any break in service. In 2016, he was demobilized from service on the ground that a criminal case was initiated against him. That criminal case from 2016 till date is continuing, my lord. And the demobilization order, that is page 26, is still continuing, is not been removed.
He was engaged as a contingent menial.
Many.
On which date?
2004, my lord, page 17.
17.
One second. 16/8/2004, my lord.
And where is the demobilization order?
Page number 26. for all practical purposes, they were utilized as a Group D employee, my lord. And he was demobilized. Criminal case is continuing for last 10 years. My lord, kindly come to page number 20, my lord. That is the governor is to sanction release of wages of contingent manual, my lord. To 47.
Yes.
My lord, there is no provision for demobilization as per service rule, my lord.
And you are appointed under which provision?
My lord, I was appointed as a CC manual.
Yes, under which provision we are saying? You are saying there is no provision for removal. So under which provision you are engaged?
He was, my lord, my appointment letter which I have in the hold, that is as page number 17, my lord.
We are asking you under which provision a person can be engaged by the superintendent of police as a menial on 700 rupees per day. Where is the statutory sanction? Where is the source of power for such engagement? Is there any provision in the WBSR for such engagement? No. There is a police act. Is there any provision in the police act for such an engagement?
But he is working from 2004 onwards, my lord.
You say that he is required to the protection under WBSR. How do you say that?
My lord, I am saying he will be governed by the, as per the service rule, he will not.
That is what we are saying, WBSR. You say he is entitled to protection under WBSR. How can he get that protection? You come to page 43 of your writ petition. Paragraph I. How you can claim such a benefit? Cannot claim such a benefit. So what is, therefore we are wondering what is wrong with the order of the Honorable Single Judge or the tribunal, sorry.
There is no inquiry, nothing, my lord.
Correct.
No show cause, nothing.
That is admitted position that they are not saying that there was any.
He was just demobilized, my lord, until further order.
So again, we are asking you, you have raised the ground that under WBSR, he cannot be removed like this. How the WBSR, therefore we asked you under which provision you are appointed, that WBSR will apply to you.
My lord, kindly give me some time.
Sorry, yes, enough, take down. Heard the learned advocate for the writ petitioner and the learned advocate for the respondents. The writ petitioner
Item number 8.
Right, 8, my lord, I beg to appear for the petitioner. my lord. This is my affidavit of service. At the outset, my lord, I apologize that the OA is not annexed with the writ. But I'm seeking liberty from your lordship to file a supplementary affidavit annexing the OA, my lord. If your daughter is pay 55.
Yes, what is wrong with the order? Let us see.
My lord,
Yes,
Petitioner himself mentioned that he is bar.
what is wrong with the order?
but today itself, my lord, I have got hold of the OA. No, my lord,
Oh, we are looking at
there
the
is, my
order.
lord, that the OA has been dismissed on the ground of delay.
No,
One, my lord, and the second part is that the admit card was not produced at the time of hearing.
so both grounds. What can be done?
No, my lord,
So we are asking you what is wrong with that order?
but I'm challenging the recruitment process.
How can you? You are required to challenge it diligently, not whenever you feel like it, not wait till the publication of the result, handing over of appointment letters, then you will challenge.
But unless until I come to know of that, I'm having the
So
knowledge.
that is your one submission. Any other submission?
But my other submission, my lord,
So according to you, the challenge is as diligent as possible.
my lord, so far as, my lord, if I take up, my lord, the same thing, my lord, if continuing wrong is there, my lord, I can challenge, my lord.
Okay, all right. Continuing wrong. That's another submission. We would like to be
Thirdly,
enlightened.
my
on
lord,
this.
would be,
The concept of continuing wrong will apply here.
my lord, may I?
Anyway, you can
Today
submit.
I'm only praying before lordship to grant me liberty to
Not required, sir. We are asking you. The order is before us. You
Yes,
tell
but
us what
the
is
OA
wrong with the
OA
order.
needs to be produced before your lordship.
Not required. We are asking you what is wrong with the order.
But
Show us the order.
But so far as the recruitment procedures were considered the essential qualifications that were required, but I was there with it.
We don't know. We are not concerned. We are asking you why a belated application can be entertained when the appointment letter has already been issued. Answer that query, then we'll go into everything.
My lord, admittedly, my lord, I was overaged. Admittedly.
Yes.
That is the
So that will
hurdle.
justify.
Yes, that is the hurdle, and I cannot
So that
justify.
will justify coming late
No, my lord,
because you are overage.
But as an officer of the court, I cannot justify that since I am
We are asking your assistance as an officer of the court
Yes.
only. We are asking you. You filed a belated application. The tribunal said everything is done. Appointment letter issued. They are not parties. We are not going to entertain. You say that because I was becoming overage, it should be challenged. That will consider.
the essential qualifications that were mentioned in the advertisement,
You cannot take us to the merit unless you satisfy us that it was maintainable the way you have filed it. Then only we will go into the merit. You may try very hard, but we are asking you after issuance of appointment letter. You did not even state that you participated. You did not even produce the admit card. As if a PIL is being filed.
No, my lord. Suddenly, my lord.
Whether a
But
PIL
I
can
bow
be
down, my
filed.
lord. So far as that part is concerned, my lord, I should have been diligent to file the admit card at least.
No, you did not say you
Yes.
participated.
No,
You did not say you participated.
but that's the only. But if your lordship kindly takes up the application, which I have got to develop,
Yes.
6.5.
Give us.
Here, my lord, there is an ambiguity. In this OA, my lord, I say I have participated. And in that application 6.5, the averment is that I wish to participate. But that two things are contrary to each other. Admittedly. Therefore, my lord, I sought liberty from your lordship to file the supplementary affidavit so that I can
No, we
produce
have got it. We have seen it.
the admit card, which I have.
We don't want, we will not allow you. Even if you have it, we will not allow you to produce now. Even if
Yes,
you have, we will
certainly,
not allow you to
because
produce.
of the passage of time, my lord. Suddenly, my lord, I have.
We will not allow.
Now, I cannot better my case when I was not diligent enough
That is
before
why-
the first court, my lord. Now, my lord, my only submission is that when I had the qualification, that should have been considered relaxing my age.
Yes.
That would have been the best case. But the OA.
Unless you apply, unless you apply, how they
Yes, my
can
lord, I
consider?
cannot improvise in appeal. my lord.
Anything could have been considered if you had applied. You never applied.
No, I had applied. I have the
No,
admit
sir,
card.
6.5 is your averment.
Yes, my lord. That is the whole hurdle, my lord.
You only
Admittedly.
wanted to apply. You did not apply.
No, my lord, the statement is ambiguous. I understand, my lord.
You
I
have
the
to
admit
go
card.
by the statement of your client.
Yes, my lord, I
You
understand.
cannot make out your own.
Put it on oath.
Yes.
Now, my lord, I have the admit card. If your lordship kindly gives us one day time, I'll produce it.
Not required, sir. That will not, that
is
will not
my
help you
only
anyway.
submission,
Sorry. That will not help you in any way.
Because the averment is on oath, my lord.
Yes,
In appeal, my lord, I cannot improvise it.
Therefore,
Admitted
what
fact.
can be done? It can be done. And what is the date of the result? What is the date of the result?
13 September 2019.
13/7/2019.
September, 13 September, MRP is 37.
13/9/19. Page?
Page
37, annexure P5.
37.
And OA has been filed in 2020.
Yes, my lord.
What can be done? Nothing can be done. Yes, take down. Heard the learned advocate for the applicant writ petitioner. We'll pass the order after recess. His lordship has a bench at 1 p.m. Another.
At 2 p.m. I may not be here.
You may not be here, not. But you can pass it after there are some matters fixed at 2 p.m. after that.
Great. देखिए कि what are-
Yeah, Mara.
Absolutely.
Yeah.
No, what is the problem?
yesterday afternoon. I have sent for instructions, but my lord, not even 24 hours has passed.
So for the respondent.
Yes, my lord. Yesterday afternoon it has.
On the appellant side.
I,
You want to confuse us?
I missed.
That there is.
Yes, but I need to take instructions.
There is a appeal prepared by my learned friend, which appearing item number 11. First
Against,
item
against the same order.
same order.
Same order, this is a cross appeal.
দিদি আমাকে বলতে দিন please. And I have filed about the cross appeal only for about paying for interest fees. And the entire order pass following the Maya Bauri. So my lord, Maya Bauri also appearing item number 5. So my humble submission, and in fact, my lord, the last occasion, the Maya Bauri was my lord argued before your lordships, and lordship was direct to file my lord the compilation. And I have my lord filed the
My lord,
compilation.
these two matters are appearing for the first time today. It was not taken up before.
How many times will you say that, madam? You have said that already.
No, my
You
lord.
are an appellant in item number 11 arising out of the same order. What instruction you will take? And will we travel beyond the writ order? Will we travel beyond the writ records?
My lord, in that case, there is a distinguish between the
So
Maya
we'll see.
Yes.
It is a question of instruction.
My lord.
Yes.
So, my lord, my humble submission, lordship can take it up for Maya Bauri. In Maya Bauri, because all my lord item 1 to 11, all are matter relying on Maya Bauri. All the judgments passed by my lord honorable Singh.
And who is appearing in that case?
My lord, my lord, Didi, একটু sir.
1 to 11 are all arising out of the same matter.
Yes.
They are all.
That's, my lord, 7 except my lord the item number 10.
Why?
9 and 10.
How 10 is different?
Because well, this is a different set of advocate, but the order pass relying on Maya Bauri. This is also relying on Maya Bauri.
So I am entering item number 9.
Yes.
9 and 10 is also relying on the Maya Bauri.
And the last occasion.
No, at the moment we are only concerned with whether all these matters are based upon the decision in Maya Bauri. Then of course we will hear everybody. We just want to ascertain that it is all arising out of the same matter. So there is no dispute that they are all arise based on the decision in the case of Maya Bauri. You are appearing in
Worship in item number 2 to 5. I am on behalf of Eastern Coalfields Limited, item number 2 to 5. And then 5 also.
The issue is that if we decide 5,
Yes.
the other cases automatically. And 5, there is a cross appeal. Also.
Yes, there is also cross
I have
appeal.
filed a cross
You are
appeal.
there.
Yes. Cross appeal, my lord, item
Which
number
one?
8.
Item number 8.
8.
Yes.
Yes, your lordship.
So 5 and 8 we can consider.
Yes, your lordship.
Let's just record in order. When the first case is called out, then an advocate stroke S representing the parties submit that the appeals involve a common issue to stop the order stroke S passed in the writ proceedings in the matters other than APOT 205 of 2025 and APOT 267 of 2025 are relying upon the decision passed in WPO number 33 of 2025. Full stop. There is therefore no dispute that the other matters are dependent upon decision of this court in the appeal arising out of WPO number 33 of 2025. For a change, the issues being common, and in view of the submissions recorded above, we proceeded to consider APOT 205 of 2025 along with APOT 267 of 2025 as the lead case. Yes. Five.
My Lordship, on the previous occasion, there was direction to file a compilation of judgments. I have filed it. I hope it is on record. Lordship, the order is in the supplementary affidavit to the stay application. Main order.
The order of the writ court.
Or order of the writ court.
The binding compilation of my learned film and my lord, this compilation.
You have also given a compilation.
This is my compilation.
So, does the compilation contain different judgments or the same judgment?
My learned friend relying one judgment, Dukhani Bhuiya, which was my lord, the Honorable Supreme
Lordship,
Court.
I'll just indicate. Lordship, on the previous occasion, your Lordship has taken up this judgment, and your Lordship had expressed the view that since this Mayabadi judgment relies on two judgments of this High Court, that is Putul Ravidas and Sumi Karim. These are two judgments. Putul Ravidas is a 3-judge bench, and Sumi Karim is a 2-judge bench. Your Lordship had expressed the view that we are bound by whatever has been held in that case. Lordship, if your Lordship takes up these judgments, the main crux of this judgment is that
Again, we are asking, again, we are repeating a question. There is a compilation filed by both parties. Is there any variance in the compilation filed or it is containing the same judgments?
Most of the same. Only, my lord, I have relied in respect of interest, which is, my lord, my learned friends. Some of the matters was also appeared. That is in respect of Eastern Coalfield.
Have you seen the compilation filed by them? Apart from those judgments, have you filed any judgment? Please answer the query. We have to ask this 4 times. Is there any variance in the compilation filed? There is variance in submission, that is more than obvious. That you need not say. We are asking you whether the compilation contains the same cases. If it does, why should we look into two? We'll go by this.
I don't believe there is I don't have their compilation. I am
Why you have not shared it with him?
I don't believe it is on the same.
You have given your copy.
Lordship, I am giving.
You have given.
No, I have just given now.
Why you can't do it beforehand? We don't know. So we should grapple with two compilations even if both are containing the same judgment.
It is not, in my opinion, it will not be the same. Because
So please tell us which is the additional judgment.
Lordship, I have relied on a few judgments, that is Steel Authority of India, that is on the point of delay and latches.
We are asking you to first sort out what are the compilations composition. Every question has to be put 5 times before an answer comes.
Lordship, none of these judgments I have given in my compilation.
So they are totally different.
Different.
Very well. Then we'll look into both. You please proceed. Where is your compilation? When have you filed?
আমার নাম লেখা আছে।
No, it's not here.
কবে দিয়েছেন আজকে? না না, পরের দিনে দিয়েছি। লাস্ট
And the judgment is annexed to which pleading? The supplementary.
The Mayawadi judgment is in the supplementary to the stay application.
Any condonation is pending or not pending?
No, condonation has been completed.
Hmm.
অ্যাপেন্ড করো তাহলে। অ্যাপেন্ডে গিয়ে গিয়ে আবার কি করতে হবে রেকর্ড ডিফল্ট অফ append constituent হয়ে গেল না হচ্ছে না কুড়িটা আছে জিরো আছে দাও
So which of these two judgments is by a three judge bench?
Putul Ravidas. That has admittedly traveled to Supreme Court also, and Supreme Court has also upheld it.
Sorry. Yes.
Lordship, shall I continue? So, Lordship, in this judgment, Mayabodi judgment, has relied on this Putul Ravidas and this Humikari. Lordship, in the basic of the crux of these judgments is that the theory on which it revolves is that there is a beneficial scheme. Beneficial scheme should be given the best possible interpretation in favor of the beneficiaries, and therefore, in case of compassionate employment or monthly monetary cash compensation, the right crystallizes as soon as the death happens, and it has even gone to the extent of holding that a person need not even make an application to that aspect. Merely on the death, even coal companies have that burden to inform them of their rights and tell them what to do or not to do. So now to this I cited as judgment of the Supreme Court, that is the Dukhira Eastern Coalfields versus Dukhni Bhuiya. Your Lordship had that was also a judgment of this High Court, division bench of this High Court. Against this, an appeal was preferred Supreme Court, and in that appeal, SLP, initially it was interim order was granted that for 3 years. Since in that case, what happened is that the applicant died in the year 1999, and this application was made in the year 2020. Supreme Court, in the facts and circumstance of the case, held that we are allowing. We are rejecting this, we are quashing the judgment of this High Court and only allowing it to the extent that 3 years prior to the making of this application, this is to be paid. Your Lordship had opined that.
Where is that judgment?
Your Lordship, in the list of cases.
Where is it?
Page number.
Which page?
Page number. Just a minute. First judgment, Lordship, page number is. Lordship, page number is 1 and 2. That is the first judgment. This is the order of the Supreme Court. Your Lordship, after reading this judgment, Your Lordship had held that it says that in the peculiar facts and circumstances of this case.
So there being a delay of about 11 years.
21 years.
21 years.
Yes.
In 21 years.
Yes.
The
So in that case,
the interim order directing for payment was not interfered with. But as regards interest, the apex court said that in the facts of this present case, whatever has been paid is sufficient.
Yes, since 3 years was paid by ECL after the interim order, Your Lordship.
3 years, it was paid from 3 years prior to?
3 years prior to the date of application.
Where
Lordship,
is that?
kindly see the interim order. Page number 3.
We don't find that here in the order.
3 years prior to the date of the filing of this petition. Page number 3.
3. But there is another order.
That is the interim order, which was which Supreme Court held that we'll continue with that order, will not interfere with that order. The final order was 13th October 2023. The interim order is 21st April 2022.
So this was complied with.
This was complied with.
That is why the subsequent order has been passed, page 1.
It was passed. But Your Lordship was of the opinion, since it states that it is in the peculiar facts and circumstances. Therefore, we are not bound by this judgment, and we will be continued to be bound by the judgment of this Putul Ravidas and the Sumikari.
That has been affirmed by the apex court.
That has been affirmed by the apex court.
That is laying down the law. This is in the facts of this case.
Yes, Your Lordship, to that I don't disagree
Yes.
to that aspect. Your Lordship, through this compilation of judgments, last day also I tried to impress upon this, that this is undoubtedly it is a beneficial scheme, and it emanates from NCWA, and NCWA is a bipartite agreement, no doubt. But Your Lordship, if we see the jurisprudence of, I was trying to draw a parallel with compassionate appointment, because in this Mayabori judgment and Putul Ravidas judgment also, there is a discussion of compassionate appointment. But what is happening recently in the Supreme Court in various judgments, and one of the judgments I have given, Lordship, it is Steel Authority of India versus Gauri Devi. This has held that.
Where is the judgment affirming the decision passed by the coordinate bench? The Supreme Court judgment affirming the earlier judgment, where is that?
Supreme Court judgment affirming the
Either Sumi Kaman or the other one, Putul Ravidas.
probably they will. I don't have it.
This is Putul Rubidas, appeal before the Supreme Court.
So this is affirmation. This is not a dismissal. The reasoning given by the High Court, in our opinion, are correct and sound. Hence, no interference is required.
Yes, Your Lordship.
Attend final.
So this is Putul Ravidas. This is the three-judge bench.
Three judge bench which has been affirmed by the
So
Supreme
this
Court.
has held that both compassionate appointment and MMCC are automatic.
Automatic
Both.
germinates from the date of the death of
Date
the
of death.
and
that
there
is
nothing-
affirmed by the apex
Yes,
court.
Your Lordship.
No application. No application.
Even it has.
When we say automatic, that means no application is required.
Lordship, this in my submission, I was trying to impress that probably the ends of justice has been stressed a bit too far, because what I am trying to submit is that delay and latches is something that is very fundamental, which runs through the entire writ jurisprudence. Because delay and latches, because when a party comes to the High Court seeking relief on the grounds of extraordinary reliefs under writ jurisdiction, delay and latches should be actively considered, and for that purpose, Lordship, I had I have submitted these few judgments.
How can you argue that? Is it open for this court to consider such argument?
Lordship, these judgments have proceeded on that basis that it germinates from the date of.
No, it is not a question of a judgment. It is a question of a pronouncement on the very scheme that we are discussing. It's not law that we are trying to look at. It is the Supreme Court's verdict on your scheme. Where is the scope for this court to examine what the law is regarding delay and compassionate appointment?
Lordship,
This scheme has been held to be automatic.
But
So
Lordship,
that finding cannot be upset by a High Court in 226
Lordship,
or in a intra-court appeal.
but subject to correction, Lordship, I was trying to.
Therefore, the primary issue is you are an officer of the court.
Yes, Your Lordship.
Is this open to argue before a writ court when the scheme itself has been held to be automatic for both benefits? And that judgment of a larger bench of this court has been affirmed by the apex court. Where is the question for us to look into it? That does not remain res integra. There is
Lordship,
nothing to be seen.
Lordship, the principle of ratio decidendi, what it states is that a judgment is binding.
Decidendi and all that will apply if we are trying to look at the ratio. We are not looking at the ratio. This scheme has been decided. We are not looking into any ratio.
Lordship,
this scheme has been decided. It's not some other judgment that.
Lordship, the reasoning for arriving at a decision is also very important.
So therefore, can you argue that before this forum that there is a flaw in the reasoning by the larger bench and by the Supreme Court?
I was trying to take a different route and
You can try many things, but we are asking you as an officer, is it open for you to argue such a thing, and is it open for us to consider such an issue? It is not.
Each and every case, there are some differences.
No, sir. There is no difference. There may be difference in the case with reference to the period.
Yes, Your Lordship.
But the fact that it applies automatic, now there is no scope for this court to look into it. We cannot consider that if there is a delay, then the claim will be defeated. The apex court, the larger bench said automatic, affirmed by the Supreme Court.
Lordship, what I wanted to impress upon Your Lordship is that it is fine. It is a beneficial legislation. It should be interpreted in favor of the beneficiaries, all of that. But Your Lordship, kindly just consider this for one moment. Can, in the name of beneficial legislation, something can be prolonged for decades? Because that is what I am, a few judgments which I have brought in this.
You cannot argue that. It does not lie in your mouth to make such an argument today. It does not lie in your mouth to make such an argument. There is no scope for such argument. You have suffered the judgment. You are one and the same entity. And you are a state within the meaning of Article 12.
I agree.
Therefore, we are again and again saying, is it open for you? You are not a private litigant. This is a finding of a larger bench affirmed by the apex court. You are arguing before a smaller bench. You are trying to reopen things which have been decided against you in respect of the same agreement. Is it open to the state to make such an argument?
Lordship, schemes like compassionate appointment and all of these are general schemes also. I
No, they are not.
Aspect of
They are not. They are not. They are not general schemes. This is the scheme which has been
Certain
decided.
principles have been laid down by Supreme
We are
Court.
not on principles. Your scheme has been decided.
Lordship, if the
Your scheme has been decided. If you are serious on pursuing these matters, then we will consider it. But we will consider everything. Whether such a stand should be taken by the state to defeat such claims and indulge in such litigation. You are free. We are just expressing our view.
Lordship, then I can have a conversation with the clients if they want to, because since your Lordship
Be
had-
very sure, sir, and I can give you a judgment on this aspect. The state, within the meaning of Article 12, having suffered a judgment, generating litigation on the same issue, same document, same wage agreement, what is to be done? If you want, we can give you that judgment.
the writ petition was theirs, but we have preferred an appeal.
This is why we are saying appeal for the sake of appeal or appeal for the sake of something to be decided. Whether the state should be indulging in such litigation. And canvassing things already settled by a higher court. Trying to draw an analogy and ratio from some other scheme when your very same scheme has been decided to be automatic. You take instructions if you want.
Lordship, if I can have that judgment that you are referring to, I can also tell them.
Look for it, sir.
Okay.
We are very sure and we have it right here, but you look for it.
As it pleases.
Yes, you look for it. After making some arguments, being faced with the decisions rendered by a larger bench of this court in the case of Putul Ravidas versus Eastern Coalfields Limited and others, reported in 2017 SCC Online Calcutta 13128, and its affirmation by the apex court in in SLP civil number, a civil diary number 3590 of 2018, the learned advocate for the appellant submits that before proceeding further, he wants to take instructions from the appellants. Stop. The matter is therefore adjourned for availing such instructions. Stop. The cases we listed on 27th February. We are giving you 4 weeks.
Deeply obliged.
Excellent. Yes. So all the matters will be listed accordingly. The common order. We have already recorded that issues are common.
My lord, item number 1 and 11, may I be permitted, my lord?
Hmm?
Item number 1 and 11, my lord.
Yes.
I'm appearing for the respondent and the appellant, my lord. My lord, only one humble submission, my lord. that in this matter, my learned friends have also filed an cross appeal, but contempt application is pending.
Hmm?
And contempt application is pending. The returnable date is 27th.
27th.
27th of February, and they have filed a cross appeal upon that as well.
So we have kept it on
27th February itself, my lord.
Yes.
Can it be changed to a prior date?
We can do that. Yes, we can have it on. Let's have it on 26th. We'll have it on 26th, one day before that.
Lordship, in
At 2
Mayapuri,
p.m.
Lordship, in Mayapuri also a contempt has been filed, and I have been informed it is coming up tomorrow.
You take steps. You can use this order. We have already kept it.
Lordship,
We all know how the bench will proceed.
Yes.
After knowing that this order has been passed, we all know how it will proceed.
My lord.
I have been there a sufficient number of years. I know. You can manage.
May the appeal be admitted, madam.
Sorry, madam. We'll see. We'll see. We can do everything. We can admit, we can pass a final judgment, or we don't know what you will be instructed. We don't.
My compilation, and after Putul Das, the others judgment passed by this Honorable Court, and it was also upheld by the Honorable Supreme Court, considering Putul Das and Rumika. I mean, that also I have.
Putul Das is the leading case because it is by a larger bench. Others are by a coordinate bench. So that larger bench gaining affirmation, then we don't, let us see what they decide. We are not saying anything. You decide what you want.
And madam, on the next date, I shall be prepared for the compilation as well also, if it is served upon me, madam. I don't want to pray for any time or anything, madam. Let a copy be served upon me. Of the compilation.
Why? They'll give you citations. They are not giving unreported judgment.
No, all are reported.
It is
You
not
take
fair.
the citation. What's the big deal?
If I can take a
the
copy, I
citation.
can
You think
make
he
a
will not
photocopy
give
and give it back.
You ask him, he will not give you the citation.
Madam, this is the
Because
point.
that order is not required.
My lord, my lord, please give me. I shall make a copy and give
Yes.
it. I
have already said all the issues.
Hey,
Item number 9 and 10.
Everything on 26th now.
2 o'clock.
Let them first decide what they want to do. Once they have decided, then issue of interest we will consider.
Appeal from order item number 12.
Yes, position. Yes.
Dada. 1 and 11.
My lord.
12, my lord, I am for the appeal. 12. The last occasion, my lord, was to see my lord one memorandum issued on a certain date which was not part of the record. So, my lord, as per the direction, my lord, I am taking that document, my lord.
My lord, my senior counsel, Mr. Somo Majumdar, is another case. Is another case. Kindly.
He will come. He will come.
That matter, my lord, may recall that.
Don't bank on us recalling matters after weeks. You please give a introduction. What is the matter?
Yes. Matter was, my lord, regarding a dispute on conversion of an employee from CDA to IDA pay pattern.
Industrial.
Yes, my industrial, my DNS pattern. So, my lord, in 1990, Supreme Court passed one decision in pursuance thereof, my lord, the
EDA to IDA in which organization?
Food Corporation of India, my lord.
So there was a scheme.
Yes, there was a circular. Therefore, by way of the circular money 2011, all the employees were given an option to convert from CDA to IDA. In pursuance thereof, my lord, the circular was put into place. Now, my lord, few of the petitioners, few of the stakeholders or the employees of the corporation filed one petition before the Delhi High Court. The Delhi High Court, my lord, initially that very first circular was put on stay. When, my lord, the second time and another application was filed, that stay, my lord, order was modified in such an extent that the corporation.
Delhi High Court stayed what?
The first circular, my lord, that is 2011, whereby my
First circular contemplating conversion.
conversion from CDO to IDO. That was, my lord, put on stay, and subsequently, my lord, that stay order was modified, whereby, my lord, the corporation given an opportunity or liberty to, my lord, recover the areas that are the excess amount that has been paid because of the conversion. And so far, my lord, the extra amount or excess amount that is to be payable, that was to be put on hold. So far, Delhi High Court order was concerned. In pursuance thereof, my lord, the corporation again came out with another circular, whereby, my lord, it has been directed that where the excess amount is to be recoverable, that is to be continued in terms of the Delhi High Court order, and wherever excess amount is to be payable, that will be put on hold. In between, my lord, the present the respondent or the petitioner hearing filed one application before the honorable court. That matter was heard, and all these documents were, my lord, put to the notice of this honorable court. But, my lord, the honorable court, my lord, they run a single bench, without given an opportunity to file any, my lord, the opposition, passed an order contending that those orders were in personam in nature. My lord, all the circulars which were in force, my lord, those were not challenged by the request. It is admitted case, my lord. And, my lord, the prima facie or, my lord, on the first or second hearing, my lord, the matter was disposed of, the order in full was passed. So, my lord, on the last occasion, my lord, I brought to the notice of the honorable court the first and second circular. That is in page number 11. My lord, kindly comes to page number 120 in the paper book, my lord. That is the second circular. 208 and 209.
120, right? Continue. Yes, where are the two judgments? Punjab, Haryana High Court and Delhi High Court.
Yes, my lord. Those are in page number, my lord. 181 and 182, my lord.
Paper book.
Yes, on paper. Second one.
So before the other high courts, you are defending this policy.
My lord,
They have challenged the policy and you are defending the policy.
in that case, my lord, there initially, my lord, there are two writ of petition was filed in 2011 and 2000.
That we didn't ask you. We asked you before the Delhi High Court and Punjab Haryana High Court, you are defending your policy.
I am defending my policy.
And here you don't want to implement it
So far,
because it is pending before the Delhi High Court.
Pursuant of the order, my lord, we have also came out with two circulars. And in Delhi High Court, my lord, from various parts of India, around
181.
181 and 182. Delhi High Court, my lord, around 70 parties have been added in various cases, around 5 number of cases. But conflicting claims have been filed. Somebody is, my lord.
Delhi High Court may follow our decision.
My lord.
The Delhi High Court may follow our decision.
That, my lord.
Why do we have to wait? That is what we are asking. Your
Because
main emphasis is that it is pending, therefore you wait. So if we decide before them, they will follow or they will not follow.
There are twofold argument, my lord. First is, my lord, the circular, which was, my lord, was issued in terms of that order, my lord, that those circulars were not challenged by it. And since, my lord, the opposition was not allowed to be filed, so should not file that opposition as well, bringing those circulars on the court. My lord, kindly see those circular forms.
And Delhi High Court judgment?
Delhi High Court, my lord, the order in pursuance, my lord, the operative part.
183. No. 181 is the Punjab Haryana one.
Yes, 181 and 182, my lord, is the Punjab and Haryana. 183, my lord, another matter.
Where is the Delhi High Court judgment?
Is in 49, my lord. 49 of my report on affidavit, my lord, which was filed. Another, my lord. It is not in the volume, the correct report on affidavit, page number 49. Yeah. Yeah.
$39.
49.
Now what? Where is the stay? There is no stay.
This is not stay, my lord. Stay order was different, my lord. Thereafter, this.
Where is the stay, sir? Again, we are asking you, why are you showing us unnecessary
I
order?
not get it, my lord. Stay order is in page number 45 to 40, the same affidavit.
My lord, the order was vacated, my lord.
The date, 2011. It is still pending.
Already vacated in page 219, serial 219.
219.
219 in the paper. History was
No, even if it is continuing, that stay hardly matters.
So for the circulars are concerned, kindly see my those circulars, which were result of that particular order mark, that was my first leg of argument. Those smaller circulars were not challenged, and those are binding now.
219.
1. Dated 20th May 2014.
But this is a different case. Huh?
My lord, this is Delhi High Court case.
Delhi High Court hears so many cases. We are saying this is a different case. The stay is in 7659 and this order is passed in a different case, 3365. How you are saying it has been vacated?
Well, if I can see the circular now. That case also, my lord, subsequently two interim application was filed for the purpose of release of various amount, like that of the petition was also rejected. Those orders are brought.
Understand this order. Six. Second. Applicant is the private. That is the bigger distance. Defeated. Applicant is for number 6. Applicant is yes.
So for the circular.
So the benefit they are claiming is under this circular of 39/2011.
Yes, my lord.
That you have placed today.
No, my lord. That is already on record. If my lord kindly comes to page number 120 and 208, then my lord, I can properly guide.
So what is your submission? What is wrong with the order of the Honorable Single Judge?
But once the High Court order came into force, my lord, whereby my lord, the corporation given an,
So which order you are relying upon?
my lord, that 13 order, 2013 order, my lord.
Yes.
That the recovery will continue, but the, my lord, the excess payment will have to be put on stay.
Where is that? In which?
49, my lord.
Page 49.
49 of the report. Because of this order, my lord, not towards the subsequent circular, my lord. Still in force.
All right. So because of this order, the Honorable Single Judge order is not sustainable.
Because of this order, my lord, kindly see the circular one. As far as, my lord, I can, this my case proper. Kindly come
See
to
the circular without going into the circular.
circulars, my lord, the purpose of this order, my lord, the circulars were, my lord, issued by the purpose. Whereby, my lord, all the cases where excess amount is to be recovered, my lord, we started recovering. And so far, my lord, the excess amount is to be payable, my lord, those were, my lord, put on hold till the outcome of this Delhi High Court case. That circular was, my lord, still in force, and those circulars were not challenged by them or not detailed in the
So how it comes in the way of grant of relief to them?
because, my lord, the circular was still in force, that is, those circulars are binding upon us.
How it comes in way of granting the relief to them?
Because the circular restrains us from releasing the amount. So for the
Any amount.
so for areas amount, but here the release. So for the because of the conversion, the excess amount that means, my lord.
Where is that circular?
That is the circular, my lord. 120, my lord. Kindly come to page number
120 of?
First, my lord, volume.
You are saying 120 has not been challenged.
Yes. We also could not reach that on record. 128 the type copy, my lord.
Yes. Any other circular or?
Second call. 209.
That is also required to be challenged.
08.
20?
2088. 208 is the circular and type copy 208. Zero eight and 209.
Yes.
That Delhi High Court, then 2 cases were filed. Thereafter, another 3 cases were filed, in which 70 petitioners or respondents are there, which have diverse claims on each other. You are trying to, see rather seeking implementation of the first circular, and rest which are getting benefited, like the petitioner, they are trying to, rather somebody, half of them or 30% of them, seeking washing the circular, rest are, trying to implement that order. So, when that order is enforced, where the similar relief or interim prayer on the example interim relief, for release of ABS payment was already considered and rejected by the Delhi High Court, that is on 2 occasions.
Yes. Yes. Just taking idea scale, their own decision. It is their decision.
No, there is a
Must be. What they are saying is, that Delhi High Court has said not to make it from those persons. Must be won't make any recovery. That is the this yes.
Around 78 parties are there, which are also seeking similarly. And I think on 2 occasions, similar players of High Court, the Delhi High Court, seeking the release of various amount, rather excess amount which they are found to be entitled because of the first circular. Those players have been rejected. In that case, I am thinking to the Supreme Court decision on the issue if there is an order passed by another High Court matter for the approach of other. If my lord allows, then I can do it.
Yes, why not? That is what we are here for.
This particular decision has been often finally comes to page number 6. Pending, page number 6. There is pending consideration of the party, but also through the negotiation of the also parties there in Delhi Corporation. The order dated such and such has become final. No appeal has been. The applicant could have filed an appropriate application for modification of the order of injunction committee or MEG request a court not to pass an order. It would be in conflict with another order passed by a competent court of law. The court has jurisdiction to pass an order of injunction not only under order 39(2) of the Code of Civil Procedure, but also section 151 thereof. This aspect of the matter has been considered in a review of the law governing injunction by stated. Conflict and loss of jurisdiction, where a court having general jurisdiction and having acquired jurisdiction of the subject matter has issued an injunction. The court of concurrent jurisdiction second injunction. There is no established rule of exclusion which would deprive a court of jurisdiction to issue an injunction because of the party appertaining to the same subject matter. But there is what may properly be termed a judicial committee on the subject. And even where it is a case of one court having refused to grant an injunction, while such refusal does not exclude another court or judge from jurisdiction, yet the granting of injunction by a second judge may lead to complication and retaliatory action. Thereafter, further reason has referred to, and thereafter the paragraph. A court, while exercising the judicial function, would ordinarily not pass an order which would make one of the parties to the list violate a lawful order passed by the another. So, my submission is I could see binding upon us, whereby
Binding upon you.
because of which those circular.
Why did you issue this circular in 2015? What have you said in paragraph 3 of your 2015 circular? Please read. That is why we are saying that is after the Delhi High Court judgment. You are repeatedly saying Delhi High Court, Delhi High Court. Therefore, we are asking you in 2015, you have issued a circular which is at page 208. What does it say? Third paragraph, read it.
Before that one in 13 itself, we have passed the circular.
You read third paragraph of 2015 circular. That is in continuation of the 13 circular.
Yes.
The 13 circular is referred at the top of that to page 208. Yes, that's not separate. What have you decided, which you have stated in the third paragraph of the 2015 circular?
To ensure compliance of the aforesaid orders and all the employees at present working and drawing regular salary in CTS scale in the corporation
Must be. What have you said?
Must be converted to ID.
Must be converted to ID. That is your decision.
and their regular salary of such and such onwards may be disbursed in ideally basically only.
Therefore,
it is 1 second. Thereafter, it is 1 second requested. Action may be
yes,
taken.
that we have seen recovery areas only.
Yes. So, my lord, both the issues were taken. It's not that only that. issue is
Recovery and areas only.
taken. Yes. Policy.
So what is the areas granted in this case?
All areas, my lord, they are seeking certain amount.
What has been granted by the writ court? What areas has been granted?
The amount, my lord, may I see the order? The amount has been there, my lord. $56 to $59. Amount has not been mentioned, but as per the writ petition, my lord, the court has done. My lord, may I see the writ petition? They have only mentioned the period, my lord. The amount has not been calculated. So far, writ petition is concerned.
What is the date of his retirement?
On 15, October 15.
October 15.
My lord, 30th November 2015. 30th November 2015.
He retired.
Superannuation.
First of November till October 18.
And my lord, the amount is lying with the registered.
30th November 2000.
2015. My lord, the
Why it is lying with the registrar?
my lord,
At
there
the
was
time
a
of-
previous direction
Well, we
passed
sought-
by
we
this
sought
Of
stay-
this court, of the division bench.
Well, we sought stay of operation of the land a single judge's order, my lord, so in pursuance thereof.
Is it invested
Yes,
in a short-term deposit?
interest
Interest
bearing.
bearing account.
My lord, the period for which we have, my lord, paid for release of areas salaries is from 20th November 2006 to 31st of October 2015. And in fact, my lord, after the notification which my learned senior friend had shown today, my lord, pay fixation order was issued on 23rd of November 2015. Thereafter, superannuation and on December 2015, last pay certificate was issued, which showed that the shifting to IDA on the retirement month itself. And in fact, my lord,
This
pay for November 15 has been paid as per IDA pay pattern, already paid.
Therefore, we are asking you, where is Mr. Majumdar? You see, come to page 208. There is page 208, third paragraph. You have not challenged this circular.
These are all internal circulars of FCI.
No, it was placed on record in the writ proceeding.
No, my
No, it says annexure E.
The first circular.
Hmm?
That was the first circular.
That is not the first circular. First circular is of 13. This is the later circular, 2015.
In pay fixation order also, my lord, we had mentioned that the areas, if any payable, shall be withheld if pending decision of this court case. So that was the pay fixation order, my lord. Where also, my lord, he mentioned in the month of November 2015 itself. Those had converted from CDO to IDA because of the circular, my lord. But so far, release is concerned, my lord, we went by the order of the Delhi High Court as well as the circular. For the pay fixation order, may I place at page number 54?
We have seen that, Mr. Murthy.
But page
All right, let him be here, then we'll
I had two other decision, my lord, may I place later on?
place it in his presence. A twofold submission is advanced on behalf of the
My lord, I appear for the appellants, my lord, in this matter, though I am led by Mr. Shomo Mujumdar once again. But, my lord, if your lordship so desires, I can, my lord, start.
My lord, I am appearing on behalf of the state respondent led by Lanet Pugutian, but he is busy in the court. My lord.
Yes, keep the file.
It's the matter.
Item 13.
Some other day, my lord.
This is 13.
Yes, my lord, 13 has been called on. My lord, but my leader in this matter, my lord, is here.
Hmm?
Led by Mr.
Only one. Who has given? Who has given?
But the appellant before your lordships is a body created by statute. Am not it?
The statutory body is the writ petitioner.
No, it's the appellant.
So who was the writ petitioner? Your employees.
They were employees. But they claim similar retirement benefits as the government employees. On enforcement of a particular provision of the West Bengal Labour Welfare Fund Act 1974, which has, not in my most respectful submission, which requires interpretation by this honorable court.
So they were they were working prior to this 74 Act.
No, not some of them had been employed after that.
Some after, some before.
But this board has two types of employees. One, who are government employees deputed for service in this establishment of the fund or the board. And the other categories of employees are those who had been appointed without a process of recruitment. Principally on need base, which had over the years been continued.
And now they are claiming parity with their
They had been granted
brethren within the organization who have come from.
No, they had been granted the benefit of pay revision. There is no dispute with regard
regarding pension.
With regard to retirement dues.
Retired
The government employees, not with the
with those posted in the same organization but drawn from a different source. And what is the basis for this distinction? How the distinction is sustainable?
Now, please come to two sections of the Act, being 17 and 18.
Can we? So all of them are employees who have been directly engaged or appointed.
Engaged or appointed? Not I have, because not we have filed an application seeking disclosure of certain notes and documents what necessitated their engagement. My lord, there was an MLA who said that in this local area there has to be viewing of cinemas to entertain the workers. So a gentleman was engaged. Now this gentleman has received the benefits of pay revision. Claimed by
How
the
many such employees?
But there are 121, I believe, in this petition.
And how many other kind of employees?
No, that is very few, 30 to 40.
So those drawn from the different government departments are much lesser than you. Maybe 1/3 as per your.
Because they are government employees deputed for supervision, many. And the terms and conditions of.
They are on a higher grade than you.
And not the employees were given an option to exercise as to whether they want to be retained in government service or they wanted to be absorbed in this service of the fund, of this board.
Without losing their terms and conditions.
Now, there is a specific provision in the Act which says that if they choose to opt for absorption in this, then they will not be entitled to the benefits like the government employees.
Oh, so they were in between there was an absorption of these employees also.
There was an option to be exercised. Many of them, most of them had not. They continue to be deputed employees.
So where is that exercise of option?
No, that's in the statute itself. Please have a look at section 17.
Any have retired prior to coming into force of this?
Yes, many of them had. And all these petitioners are retired employees. Please consider section 16 onwards, appointment of inspectors and their powers. The state government may appoint inspectors for carrying out the purposes of this Act. The terms and conditions of service of such inspectors shall be such as may be prescribed. Any inspector may, with such assistance, if any, as he considers necessary, being persons in the service of the government, enter at all reasonable hours any premises or place of inspecting any records, registers, documents, and notices required to be maintained and kept under this Act, or the rules made thereunder, and require the production thereof for inspection and for taking copies if necessary, and exercise such other powers as may be prescribed. Absorption of the existing staff of Labour Commissioner. The board shall take over and employ such of the existing staff under the control of the Labour Commissioner West Bengal as the state government may direct, and every person so taken over and employed shall be subject to the provisions of this Act and the rules made thereunder, provided that during the period of such employment, all matters relating to pay, leave, allowances, pensions, provident fund, and all other conditions of service of the said staff shall be regulated by the rules of the state government for the time being in force, or such other rules as may from time to time be made by the state government. Every person so taken over shall have a right of appeal to the state government against any order of reduction, dismissal, or removal from service of fine, or any other penalty imposed by the board, provided further that any person so taken over may elect within the prescribed period that he desires to be governed by the regulations made under this Act in respect of the conditions of service of the staff appointed by the board under this Act, and on his electing to do so, the provisions of the first proviso shall cease to apply to him.
So in any case, it was beneficial to the person being appointed.
It could be the pay was higher. They might have opted for absorption in this establishment and thereby.
That was not a condition precedent to their absorption.
No, it says statutorily, if he decides to be absorbed or governed by the provisions of this Act,
then he will forego the proviso 1. If he doesn't, then he will continue with proviso 1. So therefore, it was not a condition precedent for his absorption.
No.
He had the option of opting for either proviso A or for the.
So that was an option to be exercised by him solely.
So what is the meaning of the expression conditions of service?
Yes. Now please come to the first proviso, provided that during the period of such employment, all matters relating to pay, leave, allowances, pensions, provident fund, and all other conditions of service of the said staff, meaning thereby the employees of the government who had been deputed to the board.
Said staff does not mean only government.
No.
Said would have, then you will have to refer to 16, 17. Who are the said staff?
And not, please come to 16 once. The
Yes.
state government may appoint inspectors for carrying out the purposes of this act. The terms and conditions of service of such inspectors shall be such as may be prescribed. So, government appointed inspectors. Any inspector may, with such assistants, if any, as he considers necessary, being persons in the service of the government. So 16 predominantly and solely deals with inspectors appointed by the government, and he is acting with assistance of government employees.
And B? Sorry, 17.1.
17.1 is the board shall take over and employ such of the existing staff under the control of the Labour Commissioner of West Bengal. That's once again the government employees, as the state government may direct. And every person so taken over and employed shall be subject to the provision of this act and the rules made thereunder.
So what then, if this is to be read in this way, then they have been appointed
by the state government. The government says out of 10, 5 should go to the board now.
So how they have been appointed?
But they had been appointed by the board. They have not come from the government. But the manner in which they have been appointed, I have filed an application for seeking leave to adduce a further evidence, which they have opposed, but of course not on merit as such, which discloses certain note sheets. No recruitment process held ever.
Can you at this stage raise a collateral attack on their entry?
I'm not on. No, I'm only on the entitlement to the retirement dues.
So therefore, that's hardly relevant today.
No,
You have allowed them in, you have continued, you are giving them a particular pension, a different kind of pension is in issue. Then can you raise a collateral attack on their?
They are governed by the CPF under the Employees Provident Fund.
That is a different thing. Whatever they may be.
But I am not for a moment submitting before your lordships that whatever wages, salaries, revision they have been paid or granted, that is fruit of an unjust enrichment. I am not even submitting that.
You cannot also, yes.
I am submitting whether these provisions of section 17 and 18 read harmoniously give them a right.
This does not refer to them because they were not it was not conceptualized that there would be such persons. But you have allowed such persons to come in. Now, whether they can be equated with them or they are to be treated differently.
Yes, not that, because section 18 deals with appointment of persons by the board.
And they are all appointed by the
board. They are all appointed by the board.
Yes.
But I am not.
Section 18.
Yes.
Oh, we have not seen 18 yet.
Just the subsequent provision.
So, unless you want to show something else from...
No, I'll show section 18 and then one particular provision of the rules.
Yes.
Appointment of staff by board. So, this is a provision dedicated solely for the staff employed by the board. The board shall appoint such number of officers and other employees as may be necessary for carrying out its functions under this act. The board shall, with the approval of the state government, make regulations regarding the method of recruitment, pay and allowances, and all other conditions of service of the members of its staff appointed under this section. Now, these regulations have still not seen the light of the day, but they had been granted the benefits of pay revision.
Because the proviso?
That's right. No, I'll just take to the proviso. But how this proviso has to be read?
Yes.
Provided that until regulations are so made, the conditions or service of such staff should be conditions of service.
Therefore, we asked you at the outset, what is the meaning of conditions of service?
But there comes the question as to what is the condition of service.
Yes. Is it left to be answered by any court? That what all comes within conditions of service?
Not safe for the purpose of deciding the benefits on post-retirement.
Yes.
What is a condition of service as a retirement due applicable to a staff of the board? Because that is governed by statute. He will be governed by the provisions of Payment of Gratuity Act, because I am an establishment within the meaning of the act. And
you have not made the regulations. That is an admitted position.
I have not.
You have not promulgated any regulations. No. That is an admitted.
The Finance Department has turned down the framing of DCRB regulations.
Whatever it is, but the fact remains that regulations never came into existence. Therefore, the statute says go by the proviso. Proviso says conditions of service.
Yes.
As per state government. Therefore, whatever falls within conditions of service has to be given to them.
I just showed you, Lordship. There was a decision. This point was agitated by the board before the government. The government said no, DCRB framing of DCRB rules for them is not sanctioned.
We are not on that. That is your decision, your government's decision.
So the government decided not to frame this.
They may
It's
have.
a conclusive decision.
They may have. So they have not decided, but can they escape the proviso to section 18?
What is the effect of this proviso? Provided that until regulations are so made. Now, in this case, the government says DCRB regulations will not be made. The conditions of service of such staff shall be governed by the rules made by the state government in this behalf.
Yes.
Now, so far as pension is concerned, and leave encashment, these are the main three retirement dues payable to an employee apart from the medical allowance and all those things on retirement. On retirement, pension, gratuity, leave encashment, these are the three main entitlement of a retired employee, of a superannuated employee. Now, so far as board is concerned, I am statutorily liable to pay him dues of gratuity in terms of the Payment of Gratuity Act. So far as pension is concerned, I am statutorily liable to cover him as an employee within the meaning of the Employees Provident Funds and Miscellaneous Provisions Act 1952.
So which provision says that?
The law on those, the Provident Fund Act, the Gratuity Act.
When your own your very existence is under a statute, and that statute says in
These are the conditions of service applicable till such time regulations are framed.
Yes.
Now,
What conditions are to apply till such time regulations are framed?
Regarding the method of
shall be governed by the rules made by the state government in this behalf.
Method of recruitment, pay and allowances, and all other conditions of service.
So which rules is it referring to in the proviso?
Yes. Please read these rules with the second subsection. The board shall, with the approval of the state government, make regulations.
No, in 2 there is regulation. Regulations not made, then they will be guided by the rules. So which rules?
But it does not make the Act does not make any distinction between regulations and rules.
It says so in so many words.
But it says so.
In one provision, it elects to employ the word rules, and in another provision, it elects to employ the expression regulation.
Now, please come
Therefore,
to
2 different things are being talked about. There is no ambiguity.
Now, please come to 2. It uses regulations.
Yes.
The board shall, with the approval of the state, make regulations regarding the method of recruitment, pay and allowances, and all other conditions of services of the members of the staff appointed under this section.
That is because the board can only frame regulations. Rules will have to be framed by the state government.
Not if the regulations are approved by the government, not it's binding not for all.
That is a different thing. But rules is always rules by the state government. That is clarified by section 24 on the next page.
Please come to the rule making power and not the.
Yes.
The state government may, by notification in the official gazette and subject to the condition of previous publication,
make rules.
Yeah, make rules for
So
carrying
therefore,
out
the statute is clear when it says rules.
Now, please come to the areas in regard to which these rules can be framed.
Yes.
The intervals of the first part is the intervals at which or the period within which any of the sums referred to in section 3 shall be paid to the fund.
Yes.
The manner of making such payment and the agency for paying or collecting any such sum. The manner in which accounts of the fund shall be maintained and audited. The procedure for deferring expenditure out of the fund. The allowances payable to the members of the board under subsection 4 of 4. The manner referred to in subsection 6 of 4. The particulars to be contained in the notice and other manner. The form of submission of statement, the condition subject to which penalty may be remitted under so and so, the terms and conditions of service of the welfare commissioner, the terms and conditions of service of the inspectors and powers, delegation of powers and functions of the board to the welfare commissioner, and the conditions and limitations subject to which the powers may be exercised, the registers and records to be maintained and returns to be sent to the state government, the publication of report of the activities financed from the fund, together with a statement of recipients and expenditure of the fund and a statement of accounts, any other matter which under this act is required to be or may be prescribed.
That's very clear. See, the frame of the frame of the statute is very clear. The rule making power for the purposes of the act is specified. Otherwise, rule making power is derived from the proviso to Article 309. Therefore, it need not be specified. There is a constitutional source of power to the state government to frame any rules. So, therefore, the rules in the proviso to section 18.
No, please, if your lordship kindly takes the residuary power as in N. The residuary power of the government to frame rules as in N of section 24. N, the last one. The last.
Under this act.
Any other matter
under
which this act is
correct.
required to be.
That is what we are saying. That is for the purposes of giving effect to the act. Otherwise, the rule making power, they have a constitutional power under the proviso to Article 309.
That may be 309, maybe for its own employees. But that does not require any reference to this act.
There, we agree with you. It may be for the employees of the state government only, not for the employees of the board. The board can make a regulation in this regard under 25, which they have chosen not to do.
Now,
and therefore, 18(2) proviso has to be read.
Now, if your lordship kindly takes power to make regulations in 24A.
24A, sorry, we were saying it wrong, not 25, 24A.
The board may,
yes,
with the previous approval of the state government, by notification in the official gazette, make regulations not inconsistent with the provisions of this act or the rules made therein.
Therefore, the
regulation, its function.
The regulation making power of the board is very narrow.
So not act, beneath it is the rules.
But,
the regulations are
but the discretion is provided under 18 to prescribe the conditions of service.
Now, this
of
is with the
employees directly appointed by them. They have chosen not to do it.
Now, with that rule making, that regulation making power in 18 is with the previous approval of the state government, and to which areas? Please see. In which areas? Regarding the method of recruitment, pay and allowances, and all other conditions of service of the members of its staff appointed under this section.
Therefore, repeatedly conditions of service is being used in the statute consciously by the legislature. Not saying only pay, not saying only allowances, not saying other than pension, but saying conditions of service. So therefore, what is the meaning of conditions of service?
Please read this. I shall come to the hierarchy of law, as your lordships in the Honorable Supreme Court has laid down. If there is an act and if there is a regulation, the hierarchy of law will only permit the act to be complied.
Correct.
Now,
that's precisely what we are trying to indicate.
So, even if
there is no regulation,
now
we are not faced with that situation.
Suppose the interregnum situation is in contemplation now, is at hand now.
The interregnum situation is contemplated in the proviso.
That's right. I am taking your lordship a step ahead. Suppose there is a regulation which had been framed laying down conditions of service, including pension, or say gratuity. Now there is an act which applies to this board.
Then generally a specialibus. This will be a regulation framed under this special law for the board that will prevail.
In that context, not the Honorable Supreme Court has held.
Yes.
But whatsoever be the regulation, if there is an act, the act will prevail.
No, but there is no act governing this.
Not governing this.
There is, the statute says, it is a special statute for the board which says that it has to be specified by regulation to be framed by the board. But if not done, then we will fall on the provisions, conditions of service will be derived from the rules. Which rules? That is the situation we are faced with. That is the factual situation.
Now,
so if there was a regulation, then the situation would entirely change. Therefore, we cannot contemplate such a situation while considering the facts as they are.
Now, please visualize this from another angle. The framing of regulations requires a prior approval of the state.
Yes.
The state turns down this framing of regulation expressly. The employees of the board will not be entitled to DCRB benefits. But will the interregnum situation contemplated by the proviso enable them to...
The state does not mean the legislature.
Of course, the state is executive action.
So therefore, here is a statute. This is a legislative mandate.
It says that it can, it's only an enabling provision. The board shall appoint such number of officers, the board shall, with the approval of the state, make regulations regarding the method.
That is enabling, but the proviso says shall be governed. It does not give any.
So the enabling proviso
is the expression shall be governed.
So the enabling provision clothes
They enable you to do something. If you don't do it, then this shall be the consequence.
Yes. Now, what is the effect of this proviso vis-a-vis 2? What is the effect of this proviso vis-a-vis 18.2?
Yes.
Because this proviso can only explain 18.2.
Proviso is always
controlling or explaining.
Controlling or explaining or providing an exception.
Can.
Exception also. It's a very important call, you. Yes. This is the second important call today we have in these proceedings. Yes.
Now, it says, board shall with the approval of the state make regulations regarding the method of recruitment, pay and allowances and all other conditions of service of the members of its staff appointed under this section. Provided that until regulations are so made, the conditions of service of such staff shall be governed by the rules.
So what is your interpretation of this rule?
Not the government had expressly rejected the approval. It means the government has not, the suggestion of the board to introduce pensionary benefits for the staff of these employees is rejected. If by way of an interim measure, they will be allowed to get the benefits of pension like government employees, then this will probably lead to a different or completely dichotomous situation. Not reading the provisions of 17 and 18.
Where is that rejection?
No, I'll show to them.
There are two ways of looking at that situation. The other way is, why do you want to do this? You are already governed by the rules.
No, it says DCRB is not sanctioned.
Let us see.
But otherwise,
that's why we want to see what they have said in the rejection.
পেজটা কত বলো? ভলিউমটা কত?
Page 145.
It's in the volume 2.
You have the page.
No, yeah, I'm sorry, page 145, volume 2. But this is implementation of the recommendations of 6th Pay Commission in respect of employees of the board. With reference to the subject noted above, it is to state that in pursuance to of Finance Audit Department memo number of 19 and in accordance with the statutory provisions contained in the Welfare Fund Act 1974.
So this is not the order on the proposal to frame the pensionary benefits or their regulations.
They have also not the board has also not applied for framing of regulations.
146 clause 10. Next page.
Yes, that's it. I was coming to that. Currently comes to the last paragraph of page 146.
Yes.
The pensionary benefits to employees of the West Bengal, the penultimate paragraph of West Bengal Labour Welfare Board will be given after finalization of DCRB rules.
Yes. So there is no intention to deprive. You said that once it is rejected, can by way of an interim measure something be given? So there is no intention to deprive them of this benefit. No, it is just some rule is to be framed.
So DCRB rules, till such time DCRB rules are framed, the intention is they will not get the benefit. Now, please come to the proviso that until regulations are so made, the conditions or service of such staff shall be governed.
What is the date of this 146?
2022.
Okay. 7/7/20.
July 2020.
Oh, it is part of the same document. It starts from page 145.
145, the same document.
And then which other document? Yes, we have seen that.
No, they have not challenged this. Your Lordship will only have a look at the prayers in the reputation.
Yes.
Please have a look at 32, 30, yes, 32.
Yes, some other document you wanted.
Please come to the prayers at 32.
32.
Yes.
First volume. Give the volume 1.
Volume 1.
So what the Honorable Single Judge has directed? We have not seen the order yet.
Paragraphs 20 to 24 onwards of the Honorable Single Judge's judgment. 172. I'm sorry. Single Judge. Memo 3. The prayer was to direct the respondents to frame a DCRB rule for the employees of the West Bengal Board, mandamus to allow the benefit of 6th Pay Commission to the petitioners in accordance with 18.2 till finalization of the DCRB rules for the petitioners.
And what has been directed by the...
Please come to the paragraph 20 of the judgment under appeal. Page number volume 1 to 29 in volume 3.
Page.
But the relevant portion would be at. Please come to page 328. Paragraph 17. Or may I place from paragraph 16, page 327. Further, by letter dated 7 July 2022, that's the letter I placed. The governor was pleased to revise the pay allowances of the employees of the board, mutatis mutandis in terms of ROPA 19. This is a ROPA different, it's a separate ROPA for the board and other establishments, it's not the government ROPA. At clause 10 of the notification, it is stated that the pension benefits to the employees of the West Bengal board will be given effect to after finalization of the DCRB rules. This court had suggested to the Learned Advocate General that a period of 2 months shall be given to the state to frame service and pension regulations for the employees of the board in default whereof the DCRB scheme of the state as applicable to the state government employees would automatically become applicable to the employees of the board. The Learned Advocate General could not make any commitment before this court. Admittedly, the petitioners are receiving ad hoc pension, which is a fraction of the regular pension payable to state government employees. There is absolutely no difference in the service conditions for the petitioners and the employees of the state government. This is where not probably, which is factually not supported by any material, or even statutorily it can't be so. The board is an alter ego of the state. The employees of the board, albeit, cannot be deprived of any benefit being given to the state government employees. The employees of the board are bound by all the terms and conditions of service applied to all state government employees. This is for the deputationists, not for all, not for the staff of the board. Therefore, they cannot be treated differently merely because the state government has been completely inactive for 50 years in framing any service regulations for them. The state cannot mete out a stepmotherly treatment to the employees of the board. The state, in not framing service regulations for the petitioner for 50 years, must be deemed to have acted in a manner which is manifestly arbitrary in view of the discussions made herein above and the non-committal attitude of the state. there shall be a writ of mandamus directing the finance secretary and the chief secretary as also the principal secretary of the labor department to forthwith allow full pension to each of the petitioners as was and is payable to the retired state government employees. All revisions of pay applicable to all state government employees from ROPA 98 till ROPA 2019 shall be applied to the employees of the West Bengal Labour Welfare Board. The pension shall be payable to the petitioners from the date of their superannuation. If any of the petitioners have received the employer's share of contributory provident fund, they shall refund the same along with interest at the rate of 6% per annum within the period of 2 months from the date, that is July 31, 2024. The quantum of refund shall be communicated by the West Bengal Labour Welfare Board to each of the petitioners in consultation with the DPPG West Bengal. Let pension payment orders be issued to each of the petitioners by 17th August. All arrears of pension accruing from the date of superannuation of each of the petitioners till the date of actual payment, together with interest at the rate of 7% per annum, shall be paid to them within a month from issuance of the PPO. If any regulations are framed or proposed to be framed by the state under 18.2, the benefits conferred thereunder to the employees of the board shall not be in any way less than that being paid to the employees of the state government. But admittedly, the employees had been governed by the Provident Fund Act.
So the Honorable Single Judge has proceeded on the premise that this is an alter ego. Substantially, they are state government employees. And therefore, there can be no disparity. Not considering the effect of the proviso of 18.2.
18.2 vis-a-vis 16 and 17.
No, according to you, 18.2 deals with the employees deputationist. Going by that provision, the Honorable Single Judge has said that they are entitled to everything. We are on a different thing. We are saying proviso when it says shall be given and when it uses the expression conditions of service. Then what is that?
Now, if I may try to put it in this way, provided that until regulations are so made, the conditions of service of such staff shall be governed by the rules made by the state government in this behalf.
Yes.
Now, what are the rules which are made by the state government in this behalf? Let's say for the employees of this establishment and alike establishments, there are different set of ROPA, which is not alike the state government employees. But this will not, in my most respectful submission, relate to pension as payable to the government employees, because if this is juxtaposed to the proviso to section 17, which gives a right to a government employee who is seeking absorption in the establishment not to have the benefit of government.
It is not mandatory.
It's not mandatory.
He has the option to elect, meaning thereby the scheme of the act intends to give the better of the option available.
It could be like the state government employees who are absorbed in FCI service. But at one point of time, all the employees, a large number of employees of the Essential Commodities Department, they were absorbed in FCI temporarily and they were given an option. But with exercise of option, many of them found that since it's a central government organization, our pay revision would be higher and gratuity entitlement would be more. So they opted for this FCI service, meaning thereby, as a consequence thereof, they lost the pensionary benefits.
So therefore, the intention of the act is very clear, to give the better option, to make available the better of the choices.
But not the best of both worlds.
Cannot be. Nobody, even they don't want.
But it could be, they were getting higher pay, they were getting better gratuity, they were getting better leave, they were getting other
board.
Could be.
No, but these are not facts.
But this is option exercisable. Not one who opts is stopped from raising any issue thereafter.
No, see, these persons who are before us are not those who have opted.
No, they are all employees of the staff.
They are employees. There is no
They are
question
all
of
staff
any
the board.
option.
No, I was saying in vis-a-vis an employee. So what was contemplated in section 17 for those employees. But once one who exercises option becomes an employee of the board. So whatever birthmark he might have had in relation to his service career, he has lost.
No, that is not for these persons. That is for the other.
So he comes at par with the staff appointed by the board.
And admitted position is they are getting the pension as per DCR.
They are
There is
not.
no dispute on that.
If they have chosen or if they have opted to apply to come under the service of the board, they are not getting. Because they have a different.
How many are there such employees?
They have a different ROPA for them. They have a different.
Probably not a single. Nobody would have opted. They would have retained their benefits from the state government. So practically, they are having the best of both worlds.
Possible they have withdrawn.
Withdrawn?
They have withdrawn.
No, we don't know.
It's not continuity of service for them.
We don't know. Those facts are not here.
No, they are not before your lordship's court. Now, I'm not. If your lordship will kindly have a look at it.
And plus, they have no grievance against those who have been getting whatever they are getting by virtue of deputation. The fact that they have retained their birthmark and they are continued as state government employees under the statute 18(2), they are not raising a grievance about them.
Now, this section 18, which gives power to the board to appoint staff for the purpose of carrying out the provisions of the Act, but this also finds support from Rule 24
of
the rules. It's just after the Act.
But there is a rule also.
In the compilation, just after
Rule?
Rule 24. The board may appoint such number of officers and other employees as may be necessary for carrying out its functions under the Act and shall have disciplinary and administrative control over them. Terms and conditions of service of inspectors. The state government may by notification appoint such persons or such class of persons as it thinks fit to be inspector for the purposes of the Act. The state government may by notification divide the inspectors into so and so, that I need not trouble your lordship. Now please see the Rule 27. Limitation of expenditure towards staff. The total annual expenditure of the board towards staff, including the staff employed for carrying out the programs of the board and other administrative expenses, shall not exceed 50% of the annual income of the fund. Provided that the board may, for reasons beyond control and with the previous approval of the state government, incur expenditure beyond the limit specified in this rule. So, when his lordship holds the board to be an alter ego of the state.
No, he anyway, yes.
But may I seek your lordship's liberty to refer to that judgment of the Honorable Supreme Court? I have not brought that. But kindly recollect that Bihar school teachers case, Kopila Hingorani, the first one.
Yes.
But that famous judge.
Bihar State Road Transport Corporation.
The teachers, the primary school teachers of Bihar, but they were not getting salary from the respective aided schools or unaided schools. So they came to the Honorable Supreme Court through a public interest litigation filed by Mrs. Kopila Hingorani, whose daughter has now this NGO which runs this.
Yes, yes, I remember that case.
But there the Honorable Supreme Court explained, although they are doing certain duties which the state ought to have undertaken, although this is elementary education which is being imparted to the students, but still they are not employees of the government and therefore the government does not owe any duty.
No, but the same learned counsel espoused the cause of employees of the Bihar State Road Transport Corporation, where they were not getting anything, and a plea of financial stringency was taken by the state. There was a direction to pay.
But not as a proposition, there is a direction to pay, but as a...
Because they were employees of the board. Education is slightly on a different pedestal because there is a concept of affiliation recognizing that the preview of the government is not permitting it to spread education throughout the country. Therefore, there is a concept of affiliation. Some of it is done by these organizations which are affiliated. So the very premise of affiliation is lack of funds. Therefore, how a direction can be given? So that is not the situation here. Here there is a board. This board has a statutory existence. The employees are employed under a provision of the statute. What are their conditions of service provided in the statute?
It's not this
There can be no parallel with affiliated school teachers or such teachers who are aided by the government.
Correct.
It's
Now,
not
but-
such a
So,
circumstance.
the same statute.
So once they are employees under a statute, can you take a plea of financial stringency?
Let's say, the case of a body created by statute.
And if there is a financial stringency, how you are paying everyone else? It is not that everybody is getting half of their salary or 1/4 or 3/4.
No, it's not a everybody. Now, it's not a. But your lordship will be pleased to find that 2022 document, that is the pay revision, but there was a whole list of 54 bodies for whom there was a different set of ROPA. So that revised the pay.
So which one will apply to them?
The ROPA as promulgated for them.
Therefore, we are not concerned with the others. There
So
is a ROPA for them.
So that,
and that which is specified in 18 has not been done.
Now, please come. No, this has to be read. Probably section 18 has also to be read with 27. The rule.
Correct. That's why we said yes.
So
what is the meaning of 27? Does it mean that you may employ as many people as you want, but don't pay them, or pay them as minimum as possible within the funds? Or does it mean that you don't employ so many people, but what the number of people you employ must be paid what they are due?
Yes. Now, that's what the.
How is it to be read?
It's a balance. You don't engage or employ indiscriminately.
Correct. It doesn't mean that you engage indiscriminately and pay them 5 rupees a month because you don't have the money.
That's the budgetary check. If you do so, please come to this.
And it is nobody's case that anybody in excess has been appointed.
I am not going into that question.
Those issues were never.
The records will only go against me. How the minister's recommendation or the MLA's requirement has been fructified into employment, I don't want to go into.
Even if we keep that aside, because there is a conscious decision to pay them ad hoc pension, therefore there is no issue. Now, legitimacy is not an issue. The legitimacy of their existence is not an issue.
Not his lord. The upshot of the Honorable Court's order is the employees who were otherwise employees within the meaning of the Provident Fund Act and thus had contributed to the Provident Fund scheme, which is once again a provision, which is a special statute for the purpose of maintaining the fund, and who are otherwise entitled to the payment of gratuity act, which they would not be entitled to had they been beneficiary of the government rules. It would have been limited to say 6 lakhs of rupees as on date, which is 20 lakhs in relation to an establishment, which is governed by the payment of gratuity act. 6 lakhs has now been enhanced to 10 or 12 lakhs. But they are beneficiaries of Provident Fund, both shares of contributions, with a higher rate of interest, which the employees of the government would not be entitled to.
Why?
Because the employer's share of contribution is not payable in respect of a GPF employee. So if the body is
why both sides don't contribute in GPF? I'm asking you particularly. You must be dealing with these cases. There's no requirement.
No requirement.
Yes. Anyway.
Because that pension is being given.
Because they have the option of deducting a substantial amount. They are not dependent on the state government putting something in their account every day.
It's probably now been limited to a particular
Now limited to 5 lakh rupees per annum, not beyond that.
So, what was conceptualized was, you come under the statute, there is a budgetary ceiling beyond which you should not expend and you cannot expend, and this is not.
Yes, please.
And this is not restricted for the purpose of paying wages to the employees only, or salaries to the employees only. Now, the rules statutorily require fund generation by the board for the purpose of bearing all expenses in relation to the employees appointed by the board. Now, please have a look at the definition of employee as given in the Act. But this is of course not for the establishment's employees. But the establishments contribute at a certain rate, which is 6 rupees per employee.
Where are you reading?
Not, I was just showing not the definition of employee.
Employee is defined in section 2.
2, 3. Not, they are not employees of the board, but they are employees of the establishment for whom the contributions are paid to the board. May I just show to your lordship the object of the Act? An Act to provide for the constitution of a fund for promoting activities connected with the welfare of labor in West Bengal and for matters connected therewith. Whereas it is expedient to constitute a fund for promoting activities connected with the welfare of labor in West Bengal and for matters connected therewith.
We are not able to find this.
The object of that just above.
Oh, object.
Yes.
Yes, that we have already read.
Now, these are for the workman category of employees. The employer will contribute at the rate of 6 rupees per month. Now, please come to the constitution of the fund at page. At
6 rupees per month. Huh?
There is no such.
Where are you reading 6 rupees per month?
No, that is at page, that is in section 9. And the contribution payable by the state government and shall be paid to the board and form part of the fund. That's the fund. Now, when Rule 27 employs the word fund,
yes, yes,
it puts a limit to the expenditure on all accounts. Now, in this regard, of course, there is provision for levying penalty and charging interest on the defaulting employers. Now, please see sections 12 and 13. Power of board to borrow. The board may from time to time with the previous sanction of the state government and subject to such conditions as may be specified in this behalf, borrow any sum required for the purposes of this Act.
No, we understand what you're trying to say, but the point is either they have an entitlement or they don't. If they have an entitlement, this fund constraint, whether it can justify depriving them. And if they don't have a right, then even if you have all the funds, can they claim anything?
I was submitting that section, the classes of employees contemplated in section 16 and 17 are government employees. They have a different condition of service. Staff appointed by the board, as in section 18(2), they have a right to the extent of pay and allowances and all other conditions of service of the members of its staff appointed under this section which consciously does not mention the word pension as used in section 17.
Yes.
The moment an employee or a staff is appointed by the board, he is statutorily coverable as an employee within the meaning of the Provident Fund. But please see the difference in the entitlement as in used in section 17 proviso A with section 18(2). But for a section 17 employee, provided that during the period of such employment, all matters relating to pay, leave, allowances, pensions, provident fund, and all other conditions of service of the said staff shall be regulated by the rules of the state government for the time being in force, or such other rules as may from time to time be made by the state government.
Yes.
Now, and the moment he exercises such option, that he may forego such rights.
So 17A
17 proviso A
does not specify WBSR, does not specify DCRB.
But
17A says rules of the state government.
for the time being in force or such other rules as
And
may
the
from time to time
same expression is used in the proviso to section 18, rules made by the state government.
shall be governed by the rules made by the state government in this behalf.
Yes. So
Now the proviso says, during the period of such employment, all matters relating to pay, leave, allowances, pensions, provident fund, and all other conditions of service of the said staff shall be regulated by the rules of the state government for the time being in force.
That's what we are saying. Everywhere it says rules of the state government.
Yes. Or
it does not specify DCRB anywhere. Whether it is 17A proviso to 17A or proviso to 18.
Because not he is section 17 is applicable to a state government employee. Till such time he exercises his option, the state government
That you have said that 1617 governs government employees and therefore they cannot claim parity because they have a special provision. Section 18 governs their entitlement, and as per section 18, either regulations are to be made.
Now, had the legislative intent been that in the interregnum all pensionary benefits like the government employees are to be paid to them, then not 18(2) read with rule 27 would probably lead to a situation where the employees might have to refund on a later date.
May have to refund
on a later date.
We don't know. That is a hypothetical situation.
Not, I'll cite that judgment before your lordship also. Not if there is a law through an act which requires an employer to compulsorily pay provident fund contributions, both employer and employees share. Not being an employee of the board will not take him outside the purview of that law, even if there is a similar provision. Not that happened in the case of LIC.
When you make, you are for the board.
I'm for the board.
You are not for the state government. So concept of regularization and absorption is not new to the state government. Every day they are doing it.
The government had framed schemes for the.
They ask for the contribution to be refunded and they give the.
That's CPF GPF.
So there is nothing unique about that.
No, that's CPF GPF.
Yes.
No, that is for the employees for whom such schemes had been framed.
Correct.
Now, in so far as this is concerned, but if I can show to your lordship that there is not that in those cases, there may not be applicability of the law. Same not the university employees. For them, the Provident Fund Act would not apply, because the Act specifically excludes certain classes of employees.
Yes, yes.
Now, if I can demonstrate before your lordship that the day the employee or the staff gets appointed in the board, he comes under the purview of a different law, and he cannot have the benefit of this proviso by reason of applicability of that law. And what I'll show to your lordship, not this part, the framing of rules or not that this section 18
This is a stand you took before the single judge.
so not argued.
Then
Not a benefit which will flow from a rule can never not override the provisions of an act if some same benefit is contemplated in an act. And there is one particular paragraph in a Supreme Court judgment, no judgment, hierarchy of.
yes, a while earlier you were saying. You was
And the other is not what is general and special. Not in respect of LIC employees, a similar question arose. The court answered in favor of the employer, the employees by saying no, the provisions of that act will apply, not the rule of that particular establishment. But a similar question arose in relation to claim for gratuity by the FCI employees. A coordinate bench of our court has answered in favor that the law is applicable. In the context
the
of
law that you are talking about, does it occupy the field of pension also?
Not that DCRB rules.
No. When you are referring to some contribution being made in their.
But may I show to your lordship the definition of pension from the constitution?
Yes. We have it. We have the book.
Please consider Article 366, Sub-Article 17.
Yes.
Pension means a pension, whether contributory or not, of any kind whatsoever payable to or in respect of any person, and includes retired pay so payable, a gratuity so payable, and any sum or sum so payable by way of return, with or without interest thereon, or any other addition thereto of subscriptions to a provident fund. So here is a pension which is payable in terms of a subscription to a provident fund, which the employees will be entitled to, and
Yes.
that's by operation of law, which the section 16 or section 17 employees will not be entitled to.
So then, if the state wanted to extend the pensionary benefits under DCRB, they cannot do so.
But they may do so, but subject to
Correct.
certain conditions.
Therefore,
but not the government said that for the time being DCRB is not approved.
That's all right. When you are anyway.
No, that paragraph 10 of that 2022 letter.
27/7/22.
7 July 2022 letter.
22. We'll continue. Can you sum up your submissions in a written form so that we have it before you
But
conclude?
4 points that I shall crystallize.
Give it to us, then we'll fix a date and that day they can also make their submissions. You are for the employees. You are for the employees. You are for the state.
Yes, madam.
The learned senior advocate has made submissions. Would stop for further submissions. We are
16th.
So that
The written submission by 13th.